Good morning. I'm just checking. Guglielmo, you're muted. Can you hear me?
Yes, we
Yes.
hear you.
Um, Good morning, everybody.
Good morning. Good morning, Professor Becker.
The conference starts in, is it 10 minutes?
Right, right.
Yes.
Good morning. Good
Good
morning.
morning, Natalia.
Good morning.
Good morning, Guglielmo here. Good morning, Philip.
Good morning, Guglielmo. I can hear you very clearly.
Very good. Thank you. Likewise.
Yes. Is the first part of the conference going to be in English or in Ukrainian? We don't know.
Somebody's on mute, I think.
Yes. Well, I'll wait to see. Guglielmo, as you know, my Ukrainian is very limited.
Mine as well.
Uh, while we're waiting, how's everybody, Guglielmo? How's the family?
Very fine. Very fine. Thank you. You too?
Yes, all fine, actually. We had the wedding of our last of the three children last week. So we're we have all of them now married, and so hopefully all
yes,
settling
time,
down.
after we don't realize, the time is going by, passing by, It's,
Oh, yes, we do.
yeah.
Yeah. And do you know when you're going to be in London again? I'm sorry that the other day I couldn't meet up with you.
Yes. I think it should be in the coming 2 weeks. I haven't decided the date yet. I'll let you know and then we can meet.
Okay, let me know.
Nice to see you all. Hello.
Hi.
Hello. That's
Hello.
you.
It's a real privilege for us to welcome you here today. And we're lucky that we have online because it was a very hard night for all of us today. So I do hope that during the day we will have a peace and no alarms.
Okay. And the first part will be in English or in Ukrainian language?
Sorry?
The first part, when we start, the presentation will be in English?
Actually, we have simultaneous translation
Okay.
today. So we will have in welcome speech our Ukrainian speakers who will deliver the present speeches in Ukrainian language, and then we will proceed to our foreign speakers. But we have simultaneous translation, so it's okay.
Very good.
Good. Good. Natalia, do you want us to remain with our cameras on or off until we speak? What do you?
Until you mean while the first part, the welcome part?
Yes.
It's up to you. Actually, it's always nice to have camera on than off on the screen. But it's really up to you.
I might possibly keep my camera off during the introductory part, just so that if I move around, it doesn't disturb anyone. I'll certainly mute myself until speaking there. And may I just check that I can share my slides? I need to send a request to share my slides.
I asked our technical assistant, so let's try. We have like a few minutes before the beginning.
Yes.
So let's try if you have this ability to share the screen. Can you please check?
I've just sent a request. If where am I? I think if I am included as a what is it, co-presenter?
As a host, yes.
So host, that's right, yes. Then I can share. Prof. Oh, I see. My name appears in Cyrillic.
In Ukrainian.
Prof.
Yeah, we have in Ukrainian
Philip
language.
Becker.
Professor.
Prof. Philip Becker.
Yes. Oh, you're very good in reading in Ukrainian language.
No,
Professor Baker,
I think I can at least work out the small number of Cyrillic words there.
And may I just before this welcome part, just to introduce you with Ms. Hanova, who's head of our tax chair and head of the organizing committee, Раїса Федорівна.
Раїса.
Доброго дня. Yes, Raisa Fedorivna is here with us. So I do hope that next time we will meet offline together and we will celebrate our victory and peace. Yes.
Yes.
Thank you.
And our Mr. President is also here with us. So Professor Maisto, Professor Baker, we are like the whole team is right now here. Our Mr. President, Mr. Dashutin, Ms. Hanova, Secretary of Tax Chamber, and my dear colleague Vyacheslav Hohulyak. We will be co-moderators. Oh, Karl Shimka is also here. Mr. President, welcome.
Hello, nice to meet you.
Nice to meet you.
So now
nice to meet you too.
Now
our international partners, nice to meet you. Have a nice day.
Thank you.
I think if everyone is wearing ties and jackets, I will go and get a tie and a jacket. Excuse me a moment.
Доброго ранку, шановні учасники міжнародної
Good morning, dear participants of International Scientific Conference on Administrative Justice in Ukraine, Problems of Theory and Practice. Today we start 9th conference, which has very interesting topic for Ukraine, which is very necessary: public finance and the conditions of war, peculiarities of legal regulation and enforcement. First of all, as usual, we thank the armed forces of Ukraine for this opportunity to discuss today. Today we gather together to unite three important elements: the experience of our past, the international practice, and our current challenges. Today's event unites leaders, thought leaders, and experts from different areas of the world, and we hope that we will have productive meeting to enrich our experience, our knowledge, and to enrich us with those new ideas we have to implement every day in our difficult life and in our difficult activity. For introductory word, I have the honor to invite the head of Cassation Administrative Court as part of the Supreme Court, Doctor of the Legal Sciences, Professor Igor Volodymyrovich Dashutin. Today, under his leadership, we have the key element of the judiciary system, which has the lion's share of the burden of the highest court in the nation. Igor, the floor is yours. Thank you, Larissa Fedorovna, for this nice introduction. Today in the morning I was thinking how to start my presentation, and I could say, dear colleagues, that time changes our ideas and planning of our future, because today we had another missile strike on Kiev and Ukraine, and probably the strongest attack. Unfortunately, there are casualties. People were killed and injured, and our staff members, our rescue workers are saving people from the rubble, and this is a terrible situation that we can only feel and share one with another, but I'm convinced that our international partners also understand the conditions in which we start this international conference dedicated to public finance and the conditions of war. And it is difficult topic because over 5 years we developed the practice, and on the first sight everything may seem that the public finance covers the issues of budgets, taxation, or public expenditures. Actually, in real life of today, the notion of public finance is much wider, and in the forefront we have the issue of defense, sustainability of the society, trust of the citizens in the government, and ultimately this issue is the issue of the rule of law. The war makes us act fast, to make unstandard decisions, to implement reallocation of resources, to find new mechanisms for financing defense and recovery. Even during the war, we have unchanged fundamental principle. The strength of the state cannot be built on weakening of the law. This is why today the administrative justice gains special significance. Our task is to ensure the balance between the interests of the state and the human rights, the balance between the social necessity and legal guarantees, the balance between efficiency of public administration and the requirements of legality, I'm convinced that this is one of the missions of administrative justice in the conditions of war. Ukraine has unprecedented challenges on a daily basis. At the same time, all institutions demonstrate to the world a very important example how in the conditions of war to protect the state, at the same time not refusing from democratic values, how to guarantee security, not refusing from the human rights, how to defend independence, not refusing from the rule of law. And this is the principal difference of democratic states from the aggressive states. Today, it is very important in the tax police to preserve the balance between efficiency and legality, so that tax policy is not just effective but also fair, and the guarantee of this is independent court. The special responsibility in this process is lying on the Supreme Court. The homogeneity of jurisprudence, the legal certainty and predictability of court judgments have legal and also strategic significance for the state. When the public trusts in the court, it trusts in the government. So when they invest trusts in the court, they invest into recovery. When the citizen trusts the court, they choose the legal path to protect their rights. So administrative justice has to be a reliable mechanism to resolve disputes. It is one of the elements of sustainability of the state. It is symbolic that at the moment, together with us, we have representatives of leading European court institutions and scientific schools. Ukraine actively learns European experience, but functioning of the legal state at the same time is formed under the conditions of the full-scale war. And this experience became important for all European legal community. I'm convinced that this conference will become the platform for professional discussion, exchange of ideas, and development of new approaches, which will promote the development of administrative justice, improving the legal regulation of public finance, and strengthening of rule of law. I wish all the participants productive work, fastest recovery after this strong attacks. I understand well how what happened overnight, and I wish you a recovery as soon as possible and new professional achievements. Thank you very much to all of you for your attention, and I wish you a productive day. Thank you, Igor Volodymyrovich. Our next distinguished guest, well-known legal scholar, the author of more than 500 legal works in the area of private law and parliamentarism, Ruslan Stefanchuk, the Speaker of the Parliament of Ukraine, the Doctor of Legal Sciences. Under his guidance, the Ukrainian Parliament demonstrates continuous work under the state of war, which became the precedent for the European political systems. Please, the floor is yours.
Шановні учасники конференції,
Dear participants of the conference, distinguished colleagues, dear guests, for me it's a great honor to welcome you at this 9th International Conference Forum, which over the years of existence became the authoritative platform for professional discussion about administrative justice in Ukraine. It is especially valuable that this year among us we have heads and charges of the highest administrative courts of the partner states. Your presence is not just a sign of solidarity with Ukraine, but a demonstration that the rule of law doesn't have borders and is the basic principle of functioning of democratic states in any conditions, even the most difficult circumstances. The topic of today's conference, public finance in the conditions of war, obviously is not selected by chance. It is one of the more sensitive nodes where the interests of the state, taxpayer, and society cross. In the peacetime, the legal regulation of public finance, the issues of balance and efficiency. During the war, it becomes the issue of survival of the state and its capability to fulfill obligations to the citizens and armed forces, which defend the country from aggressor. The war makes the challenges for Ukrainian law, which was not faced by any European system of the modern times. We had to quickly rebuild budget process, tax administration, mechanisms of financial control, and to make it in a way that flexibility dictated by the wartime does not turn into arbitrary approach. Decisive role is played by administrative justice in this. Administrative justice is the safeguard which holds the public administration within the law, even when circumstances pushes it to simplification and exemptions. Although Supreme Court has no power to dictate the budget discretion of the Parliament, but it outlines the limits of this discretion. For example, in September last year, Cassation Administrative Court, as part of Supreme Court, recognized that it is illegal to apply reducing coefficients which reduce the special pensions and emphasize that to change the guarantees established by a special pension law is impossible by the decree of the cabinet ministers or by the provision of the law on state budget, only by making changes to the special law. On the other hand, in May 2025, in the exemplary case, the Great Chamber of Supreme Court recognized that the annual one-off payment to the persons with disabilities as a result of war has auxiliary nature, and that the Parliament of Ukraine can change the amounts given the financial capabilities of the state under the conditions of war, taking into account the adherence to constitutional principle of proportionality and fairness. At the moment, based on the proposal of the Supreme Court, also the issue is reviewed of constitutionality, the mechanism of authorization of the Cabinet Ministers to identify the amount of social guarantees. In this, we have the essence of a healthy dialogue of the branches of power, and the court, although it doesn't substitute budget decisions, but it forces the legislator and the government to act under Constitution and principles of Constitution. As a representative of legislature, I'd like to say and I'd emphasize the obvious fact, but basic fact. High-quality legislation is impossible without scientific expertise and without feedback from enforcement practice. The Parliament of Ukraine approved over the years a full-scale innovation and unprecedented number of financial and tax innovations. Many of them were born under conditions of lack of time, and at this conference, where the theory meets practice of the courts, the court gives us, as legislators, the fair evaluation of what works and what should be improved. So let me thank the organizers, the Cassation Administrative Court of Ukraine as part of Supreme Court, for consistency in doing this forum, and to all scholars and judges and professors and young researchers. I'd like to thank you for continuing intellectual work despite the difficult conditions of today. Your sustainability is also a contribution to efficiency and defense of Ukrainian state. I wish all the participants productive discussions, sharp questions and balanced answers, new professional contexts and practical results. I'm convinced that the developments of this conference will become a significant contribution into development of administrative justice, improving the system of public finance and strengthening of the rule of law in Ukraine. Thank you very much for your attention, and glory to Ukraine. Glory to heroes. Thank you. I'd like to invite Deputy Head of the Supreme Council of Justice, well-known scholar, Doctor of Legal Sciences, Professor, author of more than 200 works, Oksana Alexandrovna, прошу. Oksana Alexandrovna and her activity unites deep academic base and practical state governance. Oksana Alexandrovna, the floor is yours. Thank you very much for this introduction, Ms. Larissa. Greetings, I hope you're all alive and well. I'm happy that I was invited for introductions and this distinguished event. On behalf of Supreme Council of Justice, I'd like to greet you on this 9th International conference dedicated to administrative justice in Ukraine, which is dedicated very important, urgent topic which my distinguished colleagues mentioned, public finance under conditions of war. I'd like to move away from the standard statements and to wish the organizers of the conference and all of us that the next 10th conference is called Public Finance in the Conditions of Post-War Recovery and Just Peace. Of course, administrative courts play a significant role in ensuring the rights and freedoms of citizens and maintaining the balance between public interest and human rights between government and individual. In administrative justice, the principle of rule of law gains a special practical dimension because here the individual, the citizen, often looks for protection from some decisions, action or inaction of the public agencies. Since the first days of full-scale invasion, the judiciary continues to perform its constitutional function, to perform justice in difficult conditions, ruination of courts, casualties among judiciary community and staff of the courts. All this complicates the work, but it continues. Every citizen has the opportunity to apply to the court for protection of their infringed rights. I have to say that today public finance is a problem. This problem goes beyond purely budget and management problem and this unprovoked aggressive war from Russia. This is the issue of sustainability of the nation, the issue of defense of Ukraine, social responsibility and trust in government. The classics of political legal opinion links public finance not only with the needs of the public administration, but also guarantees of security and justice. You all know Montesquieu, who wrote that public income, public revenue is part of property which everyone gives to ensure the capability to use peacefully the rest. The well-known founder of classical political economy, Adam Smith, mentions that among the basic duties of the state is proper administration of justice, which is in line with financial support. So financing of judiciary is not just budget expenditures. This is necessary condition of functioning of legal state during the war, and protection of individuals, and preserving social trust and justice and to the state. For the Supreme Council of Justice, this topic is very significant, very important, because independence of judiciary is impossible without proper constitutional staff and financial support of the courts. At the same time, the martial law requires from all public agencies there is responsibility, rationality, and clear priorities. I always emphasize that without proper scientific foundation, it's impossible to find effective answers for difficult conditions of legal regulation and enforcement. And this fully concerns the problems of public finance. I analyzed, I studied the agenda of the conference, and I noticed that even in the names of presentations offered by the speakers, they show today and tomorrow we'll have a deep review of this topic and the current conditions and the conditions of ongoing war. I see that in this presentation we will unite the war context and the issues of tax and budget regulation and protection of human rights and vision of the public finance as the guarantee of recovery and development of Ukraine. This all shows that the conference is destined for success and targeted not only analyzing the problems of more wartime, but also for looking legal solutions for the future state. So, at the end, I'd like to thank the organizers for the attention to this important topic. I wish all participants and representatives of judiciary and our international partners, representatives of a scientific community, I wish you productive work, fruitful discussions. I wish you that in every city of Ukraine, at least today, we'll have a peaceful sky after nights like this. At the end, I'd like to move away from the official presentation, and I'd like to remind us that there is a saying that when there is a shortage of funds, people are saying finance is singing romance. So I wish all of us that public finance is never in poor shape, but they should be in good shape as victory, just peace, and European future. Glory to Ukraine.
Дякуємо вам щиро, Оксано Олександрівно.
Glory to heroes.
Надати
Thank you,
слово
Oksana,
голові
sincerely.
Вищої
I want to
кваліфікаційної
give the
комісії
floor
суддів України,
the
кандидату
chairman
юридичних
of High Qualification
доцента
Commission of Judges
Андрію
of Ukraine,
Володимировичу Пасічнику. Саме
PhD
під
in
його
law, associate
керівництвом
professor Andriy
Вища
Pasechnik.
кваліфікаційна комісія
It
суддів
was under
України
his
реалізує
leadership
сьогодні
that High
масштабне
Qualification
оновлення
Commission
суддівського корпусу
is
країни.
now
Андрію
renewing
Володимировичу, вам
judicial
слово.
core. Andriy Pasechnik, the floor is yours. Thank you. Thank you, Raisa. Dear judges, representative of state authorities, academicians, international partners, colleagues, it's great honor for me to speak at this conference from High Qualification Commission. On behalf of members of Commission, I thank you for invitation. First of all, well, many presenters already mentioned what happened that night, what shelling happened. So my sincere condolences to all victims of this shelling. We all understand that the road to victory is hard, but we shall overcome. The topic of today's discussion, public finances in conditions of war, looks specialized, financial, legal, but in fact, the topic is much broader. It had been emphasized already. We speak about one of the bases of resilience. It's not only finances, it's ability of the state to fulfill its functions, to support defense, to keep institutions, and remain the state of rule of law. This is extremely difficult condition, but I hope that we are coping proper way and moving in the right direction. In type of war, any decision in sphere of taxes, finances, administration of public funds gets special importance because it's not only the issue of fiscal reasonability, but issue of resilience in wartime. Therefore, administrative justice has special significance. In administrative court, public finances go through tests of lawfulness. It's the court decides what is allowable for public authority. The quality of this judicial control starts not at the moment when decision is taken. It starts earlier. Who becomes a judge? And the task of High Qualification Commission is not only to organize contest of judges. Our task is to ensure high professional, integral and independent judges work in Ukrainian judicial system. Ukraine is at the same time is fighting, reforming, acceding to Europe. In such circumstances, it's important to learn international experience. Therefore, I want to emphasize we cannot just copy this experience mechanically. The value of these conferences is to see the context, how other countries went through crisis, how judges kept balance between the need of resilience and protection of fundamental rights. Separately, I want to say that we are probably now at this stage of development of our legal system, judicial system, when we not only must study experience of foreign countries, of administrative justice, it should be done, but we have what to share with colleagues. We have case law that other countries do not have. Judicial practice in condition of war. Important is not only to learn, but also to transfer experience to other countries. I'm quite sure that today's discussion will be important not only for the scholars, for science. It has great practical importance for entire public administration, for future recovery of Ukraine. Public finance is a resource of the state, and justice is a safeguard that this resource is within limits of law and in the interest of society. I wish you all interesting, professional, daring discussion. Let its outcome become contribution to development of administrative justice, strengthening legal resilience and approximation to Europe. Thank you.
Дякуємо вам, Андрію Володимировичу.
Thank you, Andriy
З великим
Volodymyrovich.
задоволенням
It's my
хочу
great
запросити до
pleasure
слова
to
нашого друга
invite our
Карла
friend
Шимку,
Karel
президента
Šimka,
Верховного
President of the
адміністративного
Supreme
суду Чеської
Administrative Court of the
Республіки,
Czech
доктора
Republic,
права
Doctor of
одного
Law,
із ключових
and one of the
архітекторів
key
чеської моделі
architects of the Czech
адміністративної
model
юстиції.
of administrative
Пане Карле,
justice.
прошу вам слово.
Karel, please, the floor is yours.
Dear Raisa Harova, dear honorable colleagues, thank you for the invitation to the opening speech. It is an honor for me, and I'm very happy to can see again together friends from the Ukraine, from Poland, from Austria, and from other countries. I'm sitting here in summer Prague now in my home, and I'm thinking about extremes of our times. We have hot weather in Prague. We have here many tourists, and our life is quiet and comfortable. But I know very good how quickly can it change. As some of you know, I was last summer in Kiev personally, and so I could get a piece of war experience. I wasn't in Kramatorsk or in Sumy or in Kharkiv or in Zaporozhye or in Kherson or at another place close to the battlefield. I was only in Kiev and only for 3 nights and 4 days. But it was very important experience for me. The life in the war can be happy. Kiev in the wartime is at the daylight very comfortable city with fine dining, with interesting architecture, and with very colorful life at streets and squares. But at 10 in the evening is everything over, and the city prepares for the night fight with missiles and drones. It was the case at this night from yesterday to today too. I watched it in our media. You cannot sleep good because either you risk your life or you have to break the sleep and go into the shelter. And so it is day after day, more than 4 years since February 2022. I was very impressed when I was in the Ukraine, how active are the people there and how good does work the everyday economic life. Petrol station, public transport, stores and restaurants, production and logistics, public administration and justice. Everything does work quite well. The economy and fiscal situation of the country in war is something very strange for me because the last war at the territory of most of the European countries was 80 years ago. I can compare the situation in the Ukraine with something in my own life only very partly when I think about, for example, the COVID years 2020-2022, which brought our country into a high level of state debts. But it isn't economically the same case. You need now much more money for the military than we needed in the COVID time for paying the employees of our frozen farms in lockdowns. Another comparison from my national experience could be the preparation of Czechoslovakia for the war with Nazi Germany in the late 30s of the 20th century. We built at that time our fortress chain at the border with Germany and improved our army. The costs of it were as enormous as Czechoslovakia would fall in some years in very, very deep debts. But as you know, it didn't happen because we didn't fight and we were very soon occupied by the Third Reich. I think that today's financial situation of the war Ukraine isn't comparable with anything we in Europe can imagine on the basement of our experience. But I have no more fear for Ukraine. The Europeans know that the financial support of Ukraine is the best investment into their own security, and the support will continue. But as I could watch it personally in Kiev, and as I could read about it, the wartime made from you Ukrainians a very hard and very efficient nation. You learned now to innovate fast. You learned how to make good and fast decisions, and you learned how to cooperate. You learned how to solve problems. The war brought you tears because many people died or were wounded, and because many of your cities and other infrastructure were destroyed. But the economic and financial future of Ukraine after the war can be very successful because you learned during the war the effectiveness. I think you can be one of the most growing European states with very innovative and very free economic. I hope in this future of Ukraine, and I will do everything to help you to reach it. I wish to today's and tomorrow's conference many interesting presentations, and all of us a good time which we spend together. Slava Ukraini!
Героям слава, дякуємо
Glory
вам.
to heroes. Thank you, Karol.
Пару слів для
A couple of words
hello,
in
our
response.
friends, dear Mr. President. We remembered how you arrived to Kiev during the rocket attack. Allow me to express my sincere gratitude for your participation. Your commitment to professional dialogues has possessed a special atmosphere of mutual trust and partnership. We deeply value to support our Czech colleagues provide to the Ukrainian justice system, as well as the opportunity to exchange experience and jointly seek solutions to contemporary challenges. We are confident that the professional ties established will continue and strengthen cooperation between our courts and advance European standards of justice. Thank you so much, Mr. Karl.
Dear Igor, thank you, and I think our cooperation will continue. I do everything for it.
Thank you.
Дякуємо. До вітального слова
Thank you.
запрошуємо
I
голову Верховного
invite
суду,
President of Supreme Administrative Court of Poland, a person who has his experience.
який очолив найвищу судову інстанцію
I
України в
invite
23-му році,
Stanislav
прийнявши
Kravchenko,
досвід керувати системою в умовах
who
воєнного
took a
стану та
challenge
глобальних
governing the
Пане
system
голово, вам
in the
слово.
time of war. Mr. President, the floor is yours. Dear Mr. President of Supreme Administrative Court, dear Raisa Fedorivna, dear colleagues, friends, special welcome to our guests, President of Czech Court, Mr. Šimka, President of Polish Court, President of Austrian Administrative Court, Madam Bettina Maverkova. For me, it's a great honor to welcome you to this conference, Administrative Justice of Ukraine, Problems here in Practice. It's true, we have a scientific conference. I couldn't be with you from the very beginning. I don't know whether the previous speakers mentioned it. We have one important date which caused this meeting. During these days, this professional community marks an important event. Code of Administrative Justice was adopted in these days. During these days, we commemorate Days of Administrative Justice in Ukraine, and we're very proud of that. As distinct from colleagues, we don't have separate administrative court. All cassation courts are within one structure, Supreme Court of Ukraine. But we all have our own functions and powers, having the common goal that justice is fairly exercised in Ukraine. Role administrative court in Ukraine is difficult to overestimate. More and more, we talk about trust to courts. Recently, at the event that took place in Supreme Court of Ukraine, with participation more than 10 members of European Parliament, figures of trust to judges were mentioned, 22%. Then we didn't have time to get into discussion. But here I have my own comments, my argumentation. And using administrative justice, I can give my argument. Maybe people do not trust us, but more than 600,000 people in conditions of martial law came to administrative courts to ask for protection of their rights in administrative courts. Based on our studies that we conducted, more than 70% of people living court proceedings believe that decisions of court are well-founded and lawful. Of course, now we have martial law. Now, martial law caused a new group of cases connected with war, and no doubt one of the leading role is played by administrative justice. Issues of internally displaced persons, social protection of civilians, social protections of military servicemen and their families, survival of people in hard times. Statistics show that administrative justice is the core branch. If you take example of Supreme Court, almost 6% that all cases that are considered in cassation are administrative cases. When given these figures, we can say that we are really proud that administrative justice does exist in Ukraine. A political decision is taken in our country. We have separate branch, administrative justice, that resolves cases protecting rights of citizens in their disputes with the public agents. As regards to today's topic of the conference, I believe it is very successfully selected. We all know that Ukraine lives in condition of full-fledged invasion for 4 years. And actually, our fight with Russia lasts more than 13 years. And that also touches via public interest. Budget of the state is not a mere financial institute. It's a document that supports defense of the country, support of economy, protection of social system, healthcare, education. This is the basis for future recovery of Ukraine. Because of that, the format that you suggest, public finances in conditions of law, a law enforcement aspect is very important. We shall discuss today balance of interests, interest of the state, because countries should finance war and defense, but at the same time, guided by our constitution, Ukraine is a social legal country. state of rule of law, we protect the interests of citizens. Today we have a very good meeting, very good topics for discussion, and I want to wish you all the best. First of all, I want to thank all co-organizers, our participants who found time to take part today, and to wish us all fruitful work, fruitful discussion, and I'm sure that at the end of the conference, we shall be pleased not only with communication with each other, but having new knowledge, new ideas, new understanding of different processes that are taking place in the country. And we'll use them in our work. Cassation Administrative Court, first of all, is considering specific cases, and there are real people behind these cases who need our protection. Using this opportunity, I want to welcome you all. This is a holiday of celebration of administrative justice. Thank you for doing important job in time of war, and wish you fruitful work in the future. Thank you for your attention.
Дякуємо вам, Станіславе Івановичу.
Thank you,
До
Stanislav
вітальних
Ivanovich.
слів приєднується Беттіна Мауер-Кобер.
Maxina Mauer-Coburg is invited for introductory word to the Deputy Head of the Supreme Administrative Court of Austria, the Doctor of Law. For a long time, she was head of the working group on asylum and migration in the Association of European Administrative Courts, developing international cooperation. Today, her activity is dedicated to application of standards of administrative law of EU based on Austrian jurisprudence. Please, the floor is yours.
Honorable President, ladies and gentlemen, dear colleagues, on behalf of the Austrian Supreme Administrative Court, it is a great honor and pleasure for me to extend this welcome address to you on the occasion of your international conference about the challenges of public finances under martial law, which is taking place today and tomorrow. The topic of your conference demonstrates the difficult situation in which your country has found itself for several years now, following Russia's war of aggression. The Austrian Supreme Administrative Court recently had the opportunity to welcome a large delegation of Ukrainian judges led by President Tashutin in Vienna, and to receive specific information on the state of the judiciary in Ukraine during these times of war. We wish to convey our deepest appreciation for the dedication and resilience you have shown as judges during these difficult times for Ukraine. It is precisely this dedication and resilience that convince us that your commitment to upholding the rule of law will bear fruit even in these challenging circumstances. The Austrian Supreme Administrative Court feels a special historical connection with you, our Ukrainian colleagues. This year marks the 150th anniversary of the Austrian Supreme Administrative Court. When it was founded in 1876, its jurisdiction extended to parts of what now is Ukraine, and Ukrainian judges were among those serving at the court in Vienna. Administrative procedural law, which was decisively shaped by the case law of the Austrian Supreme Administrative Court, has gained recognition as a model in many Eastern European states. We are therefore pleased to have contributed to a shared European understanding of this area of law as well. When you discuss issues of financial law in times of war at your conference, you are addressing a topic that until recently was no longer considered relevant in Europe. The war in your country has taught us otherwise. The outcome of your conference is therefore of great significance. We can only hope that this war will end soon, and that your experience will help us all understand how we can avoid war and the associated suffering for a country's population in the future, for a peaceful and prosperous Europe. On behalf of the Austrian Supreme Administrative Court, please accept my best wishes for a highly successful conference, along with my deepest respect and solidarity.
Дякую.
Thank you.
Маю честь
I
запросити
have the
до
honor
першого
to
слова
invite for introduction
Сильвана Марена,
Sylvain
президента
Morin, the president of
Асоціації
Association of
Європейських
European
адміністративних
Administrative
суддів, доктора права,
Judges, the Doctor of Law,
одного із
one
найпливовіших
of the most
представників
influential
Європейської
representative of
адміністративної
European
юстиції
administrative
та
justice,
одного із ключових
and one
голосів
of the
у
key
питаннях
voices in the issue of protection of independence of judiciary in
Пане
Europe.
Сильван,
Mr.
прошу,
Sylvain,
вам
the floor is
слово.
yours.
Thank you very much. I hope that you hear me. In the name of the Association of European Administrative Judges, I would like to present our European colleagues our best wishes for this seminar. And I would also like to thank the President, Mr. Kravchenko, President of the Supreme Court, Mr. Dashutin, the President of the Administrative Cassation Court, as well as Natalia Blasevska, for organizing this seminar and inviting the AAG to participate. I see again some of you, and some of you see me again, as we have come to Lviv in February for the precedent conference organized by the same parties. It was an extraordinary moment to meet you and to be with you in Kyiv. I will stay, therefore I will be brief and not repeat what I already said in Kyiv. What I would like to say for this seminar is that, in fact, war and public finance are deeply intertwined since the medieval times, and even the institution of permanent taxes, and permanent taxes has been made to finance defense and wars. Our continent has been for a long time a continent of wars, and therefore the interactions between these two issues, unfortunately, is not new. We could say war, public finance, and revolution, but that would be another story if we consider the French case. In Lisbon, in May, the AAG, our association, had its seminar on the financial independence of administrative judges, and we have discussed the budget of court, the budgetary negotiation, the organization of the justice system to allocate and manage resources. We also discussed about financial issues and remunerations. This seminar was highly successful, with approximately 80 participants from 27 countries, and that was the most successful even in terms of country representativity. There were also Ukrainian participants, and they were very active in the discussion. So we are talking about money again. Why we administrative judges are we so interested in public finance and money, whereas it's sometimes a little bit taboo to talk about money among judges. First, because we are interested into the organization of the state, and secondly, because we deal with the legal issues related to public finance, taxation, but not only, and therefore we have a keen interest for this aspect. Eva Wendler, the vice president of the association, will also participate to this seminar, and she was the co-chair of the working group. She is the co-chair of our working group, Independence and Administrative Justice, and organized the seminar in Lisbon. Therefore, the success of this seminar was also thanks to her. And next week, I will be in Cambridge to talk again about the same issues. So, whereas everybody is speaking about artificial intelligence, and there are many conferences about artificial intelligence, we are on more original topics related to these important issues. Later in the morning, I will make a presentation because I would like to contribute on the substance to this seminar on the French situation during the First World War, and I hope it will be of great interest for you all, and therefore we will see us again in a few minutes. Thank you very much.
Дякуємо вам.
Раїса Федоровна, пару слів для
Thank you. Just a
містера.
couple of words for Mr. Silvan.
Dear Mr. Salvan, I'm glad to see you, and I remember, we remember you participating in the conference held in Lviv. Please accept your sincere gratitude for your participation in our international online conference. We sincerely thank you for your solidarity with Ukrainian judges, as well as for your friendship and unwavering support during this challenging time for Ukraine. Thank you, Mr. Salvan.
Ага, дякую.
Thank you.
Прошу до слова Олександра
I
Михайловича
pass the floor to Alexander Mikhailovich Pasenyuk, the president of All Ukrainian Association of Administrative Judges, candidate of legal sciences, one of the founders of a modern system of administrative justice of Ukraine, who played a decisive role in establishment of administrative justice. First president of the High Administrative Court of Ukraine. Alexander Mikhailovich, the floor is yours. Thank you. Raisa Fedorovna, I'm glad to greet all the participants of the conference on behalf of All Ukrainian Association of Administrative Judges, which is the member of European Association of Administrative Judges, and also on my personal behalf, as a president of association and a person who is directly involved in building the system of administrative courts and implementation of administrative justice in Ukraine. Soon we'll celebrate the 21st anniversary of adoption by the Parliament of the Court of Administrative Justice in Ukraine and restoration in our country of administrative justice. I'd like to remind you that administrative justice for many years was in exile or in the state of origin, because communism ideology denied the concept of administrative justice and necessity in modern European states. It was declared that all public agencies and their officials function and act a priori only in the interests of the citizens, so there is no need for judiciary review. But having overcome the resistance of many political forces and resistance of officials, having bypassed many obstacles, administrative justice finally came to protect the rights and interests and freedoms of the citizens. The most important in the Constitution, the changes were made to the chapter on justice. It was declared that the objective of protection of rights and citizens and the public relations, the administrative courts function to liquidate administrative courts now, and administrative justice in Ukraine will not be possible. Although some infringements on our jurisdiction continue, but the war is underway in Ukraine. It was a terrible night with terrible consequences, with casualties, ruinations, damages. I'd like to express my condolences to the families, the victims, and all citizens of Ukraine. It's the martial law implementation of administrative courts. Administrative courts received new cases related to mobilization, military service, equivalent payments for salaries to servicemen, social benefits to the families of the deceased, and also cases related to public finance in the conditions of war. As regards to the topic of our conference, I'd like to say that the fiscal policy was adapted to the war conditions, although full-scale invasion of Russian aggressor caused unprecedented economic decline, which had deep impact on public finance of the country. I'd like to draw your attention that public finance as the system of economic relations, which appears in the process of forming and allocation of funds, is not just the object of regulation by the state. Public finance is also object of legal regulation, and the main peculiarities and patterns of the regulation of public relations and the conditions of war should be treated, taking into account the national and international experience, sustainable and unified enforcement practice, and the realities of today. This practice is formed by the administrative courts of Ukraine, and they are forming this jurisprudence actively. I wish you a productive discussion to all participants of our today's conference. Thank you for your attention.
Дякуємо вам, Олександре
Thank you,
Михайловичу.
Alexander
З
Mikhailovich.
великою вдячністю хочу запросити до
With
слова
great
начальника
gratitude, I'd like to invite Natalia
керівника
Saptiska to take the floor, head of the projects unit of the program of the support of Ukraine by
Вона
OSCE.
допомагає країнам
She helps
проводити
the
реформи,
country. They help the countries to conduct reforms and to recover after the crisis, uniting international experience of OSCE with the development of the public institutions. And Ms. Natalia, the floor is yours.
Пані Раїса, щиро дякую за теплі
Ms. Raisa,
слова.
thank you very much for kind
Шановний
words.
пане голово Верховного
Mr. President of
шановні
the
учасники конференції.
board,
Для мене
participants of
велика
the conference,
честь від
for me it's a great honor on
програми
behalf of
підтримки
the
України і
Ukraine support program
учасників
of OSCE to greet the
міжнародної
participants of
наукової
9th International Scientific
конференції,
Practical
що
Conference
проводиться в межах днів
conducted
адміністративної
under the
юстиції
days of
України.
administrative justice in
В першу
Ukraine.
чергу хочу
First of all, I'd like
зазначити,
to
що ми
mention
високо
that
цінуємо лідерство
we highly
Верховного
appreciate the
суду,
leadership of
а
the
також
Supreme Court and
стійкість
also
і відданість
sustainability
української
and
судової
dedication of
спільноти
Ukrainian
забезпеченню
judiciary community in
безперервності,
ensuring continuity
правосуддя та
of
подальшого
justice and
розвитку судової
further
системи
developments
в
of the
умовах
judiciary
вторгнення,
under the
в
conditions of
умовах
today,
повномасштабної
under
війни.
the conditions of
Як
full-scale invasion.
зазначила
As it was
пані
mentioned by
Оксана
Ms.
та
Oksana
Андрій,
and
в
by
умовах
Mr. Andriy,
повномасштабної
under the
війни
conditions of
питання
full-scale
публічних
invasion,
фінансів
the
виходить
issue of
далеко
public
за
finance
межі
goes
бюджетної
beyond
чи
the
податкової
budget or
політики.
tax
Вони
policy.
безпосередньо пов'язані
They are
зі
directly
стійкістю
related to
держави, її
sustainability of the
здатністю
country,
забезпечувати
its ability to
оборону,
ensure
виконувати
defense,
соціальні
to
зобов'язання,
fulfill social
підтримувати
commitments,
економіку
to support
та
the
планувати
economy,
майбутнє
and to plan
відновлення.
future recovery.
Водночас навіть в умовах
At the same
воєнного
time,
стану
even under the martial
фінансова
law,
політика
the
держави повинна
finance policy of the state
залишатися
should
заснованою на
be
принципах
based on the
верховенства
principles of the
права,
rule of law,
визначеності,
legal
пропорційності
certainty,
та балансу
proportionality,
між публічними
and
і
balance
приватними
between
інтересами.
public and private interest.
Саме тому роль
That's why the role of
адміністративного
administrative
суддівства
justice in
набуває
this period
особливого
gains
значення.
special
Судова влада
significance.
покликана забезпечити
Judiciary is called to
ефективний
ensure
захист прав
effective
людини,
protection of human
зміцнити
rights,
довіру до
strengthen
державних
trust
інституцій
in the
та
public
гарантувати,
institutions,
щоб навіть
and
у
guarantee that
надзвичайних
even in
обставинах
the
держава
extraordinary
була в
conditions,
пределах, в межах
the
права.
state is
Особлива
acting
цінність
within the
цієї
law. The
конференції
special value of
є
this conference is its
міжнародний
international
формат.
and
Вона
interdisciplinary
об'єднала
format.
суддів,
It unites
науковців,
judges,
експертів
scholars,
з
and
усієї
experts
України та
from all
фахівців
Ukraine and
європейських
many
профілів для
European
обговорення
countries to
широкого
discuss a
правового
wide
поля
range
від
of issues,
історичного
from
досвіду
historic
правового
experience
регулювання
of legal
публічних
regulation
фінансів
of the public
у періоди
finance
воєн та
in the
криз,
period of
до
war and
сучасних
crisis,
викликів у
to the
сфері
modern
податкового
challenges in the area of
адміністрування,
tax
виконання
administration,
судових рішень, захисту
enforcement of court
фундаментальних прав
judgments,
та
protection of
знання
fundamental
новітніх
rights, and
технологій
impact of modern
та
technologies on enforcement.
Особливо цінним є
Special
дискусії про
value is
міжнародне
discussion on
запобігання
international and comparative
вивчення
experience,
підходів
studying
змін в
approaches
різних правових
formed in
системах
different
під
legal
час кризових
systems
періодів
during the crisis
дозволяє не
periods,
лише краще
which allows
зрозуміти
not only to
глибші
better
етапи
understand the
викликів,
nature of
але
modern
сприяє
challenges, but
пошуку
also promotes a
ефективних
search for
рішень для
effective
України.
solutions for
Для
Ukraine.
програми підтримки ОБСЄ
For
для України
Ukraine's support
підтримка
program of
сектору
OSCE,
правосуддя
supporting the
та
sector of
зміцнення
justice
верховенства
and
права
strengthening rule of law
залишаються стратегічними
stays a
пріоритетами.
strategic
Ми
priority.
високо цінуємо
We highly
співпрацю з
appreciate the
Верховним
cooperation
судом
with
та
the
іншими
Supreme Court and
партнерами.
other partners, and we will continue supporting the reforms targeted at strengthening independence of judiciary, raising the quality of justice, and strengthening democratic sustainability of Ukraine. I'm convinced that the discussions over these 2 days will promote not only deepening of scientific and professional dialogue, but also developing practical approaches which will help to ensure proper legal regulation and effective enforcement in the area of public finance in the conditions of war and after post-war recovery. I wish you informative discussions and interesting exchange of experience and productive work. Thank you very much for your attention.
Дякуємо вам, пані Наталя.
Thank you, Ms. Natalia.
Дякую всім за теплі
Thank
слова.
you for your kind
Переходимо
words.
до роботи
We
нашої
move to the
конференції,
proceedings of our
до роботи
conference,
сесії першої та
to the first
другої.
session and second session,
Міжнародний досвід правового
the international
регулювання
experience of legal regulation of public finance in the conditions of war.
Модераторами
Moderators of these sessions will be
судді Верховного
the judges
суду,
of the Supreme
Касаційного
Court and the Cassation Administrative Court, Natalia Evgenievna Blashivska, Doctor of Legal Sciences, Professor, and Vyacheslav Vissarionovich Hakulak, Doctor of Legal Sciences, Associate Professor. Ms. Natalia, Mr. Vyacheslav, the floor is yours.
Шановна Раїса Федорівна, шановний пане
Esteemed
голово,
Raisa
шановні колеги,
Fedorivna,
для мене
dear Mr.
сьогодні
President,
велика
dear
честь
colleagues,
разом
for
із
me
моїм
it's a
дорогим
great
колегою,
honor,
суддею Верховного суду,
together with
паном
my
Вячеславом
colleague,
Хохоляком,
Judge of
модерувати
Supreme
першу
Court,
сесію
Vyacheslav
нашої
Hochulak, to
міжнародної
moderate
конференції.
the first
Пане
session of our
Вячеславе, доброго
conference.
дня.
Vyacheslav,
Добрий день, пані Наталя.
good morning.
Сьогоднішня конференція є справді
Today's
унікальною. Вона
conference
об'єднує
is, in fact,
представників найвищих
unique.
судових
It brings
інстанцій,
together
університетів,
representatives of
науковців
judicial
Великої Британії,
instances,
Суду справедливості
academic
Європейського Союзу,
schools,
Італії,
Trade
Франції,
Union,
Канади,
European
Польщі,
Union,
Португалії,
Italy,
Австрії,
France,
Німеччини
Poland,
і, безумовно,
Portugal,
України.
Germany, and of
Особливо
course
цінно,
Ukraine.
що поміж наших
What is
гостей не лише
valuable
видатні науковці,
that
а й
among
судді.
guests are not
І
only
не просто
important
видатні
scholars,
науковці
but
судді, а
also
передусім це
judges
наші багаторічні і справжні
who
друзі
are
України.
our
Протягом багатьох
many-year
років адміністративні
friends
судді
of
України
ours.
підтримують активний професійний
Administrative
діалог із
judges of
європейською
Ukraine
суддівською
maintain
спільнотою.
active
Нас
dialogue with
об'єднують спільні наукові проєкти,
European
міжнародні
judicial
конференції,
community.
діяльність в
We are
рамках Асоціації
united by
європейських
joint
адміністративних
projects,
судів, програм
international
Ради Європи,
conferences,
Європейського
Council
Союзу
of
та
Europe
організацій.
programs,
І
EU
навіть після
programs,
початку
OECD
повномасштабної
programs.
агресії ця
After the
співпраця
start
не
of
лише не
full-scale
припинилася, вона стала
invasion,
ще
this
міцнішою,
cooperation
за що ми
didn't
вам
stop.
дуже вдячні.
On the
Саме
contrary,
тому
it
сьогоднішня
enhanced,
конференція
and we are
є
thankful
значно
for that.
більшою, ніж академічний
This
захід. Це
conference
ще
is
одне
just more
підтвердження
than an
того, що
academic
верховенство
event.
права
It's
воно
another
не має
confirmation of
державних
the
кордонів,
fact
а
that a rule
професійна
of law does
суддівська
not have
спільнота
state
Європи
borders.
залишається єдиною
Professional
захисті
community
цінностей
of
людського
Europe
в цей
is
важкий для
uniform
України
in
час. Протягом
protecting
двох
values
сесій ми
of
говоритимемо
Europe,
не лише про податки та
especially in
бюджетне
this hot
право. Ми
time. We shall
говоритимемо про
discuss
те,
not only
як ми
taxes,
змінювали
budgetary
держави,
law,
фінансові системи та право протягом
financial
останнього століття.
system, and
І,
law,
безумовно, який
how
можливо
situation
цей світовий
changed
досвід
within
може
last
дати
100
українцям.
years,
Саме таку мету
and
ставила
what
вельмишановна
international
Раїса Петрівна
experience
перед
can give to
координаційним
Ukraine.
комітетом, коли ми
That
формували
was
нашу
the
програму.
objective
І,
that
шановні
Raisa
колеги, ми не
Fedorova
випадково
set
сьогодні
to
онлайн. Це
organizing
тому,
committee.
що ми
We
дбаємо
are
про
today
безпеку
online,
наших усіх
not by chance.
учасників.
We are
Зараз з
caring
великою
about
приємністю
safety and security of all
запрошую
participants.
до виступу
Now it's my great
вельмишановного
pleasure to
професора
invite
Королівського
esteemed
брата Великої
professor,
Британії, запрошеного професора Оксфордського
Earl
університету,
advisor,
одного з найавторитетніших
visiting
світових
professor
експертів
at
у сфері
Oxford
міжнародного податкового
University,
права,
one of the
вельмишановний
most
пане
well-known
Філіппе
expert
Бейкер.
of tax law,
Запрошуємо
esteemed
вас до
Philip
слова.
Baker.
Аудиторія
The
ваша.
floor is yours.
Thank you very much indeed, Natalia. Can I check, first of all, can you hear me all right? You can, that's fine. And can I just check if I can share my slides? Let me see. Are you able to see my slides?
Yes.
All right, there. Yes, good.
Yes, we can.
Fine. Well, firstly, may I begin by thanking the organizers of the conference for inviting me to give this talk. It's a great honor for me to be asked to join this conference. At the same time, there's an element of sadness because I have spoken frequently about taxpayers' rights and human rights, but never in a wartime context. I think it is extremely brave of the organizers to organize this conference, but it reminds us that even in wartime, both the collection of taxes and the administrative justice connected with taxation continues on, and as part of that continuation, taxpayers' rights and human rights remain extremely important. And I thank you for the invitation again, and congratulate you on organizing this conference. Something has happened with the slides. One moment. I don't know why I'm having a little difficulty. Let me see if I move that. The outline of my presentation, I'd like, in the time available, to try to cover 5 topics. I want to talk about the distinction between taxpayers' rights on the one hand and human rights with respect to taxation on the other, which I think is a distinction that's increasingly important to make. I will then say a little bit about the position of Ukraine with regard to human rights instruments and taxation, and then I'll turn to talk about taxpayers' rights and just identify some of the levels of protection and particularly focus on the practical protection of taxpayers' rights. The fourth topic is really rather speculative because it's not something I think that has been studied previously, and that is reminding ourselves of the impact of war on the practical protection of taxpayers' rights and some of the adjustments that are necessary. And finally, I shall make some concluding comments. Let me then begin with the distinction between taxpayers' rights and human rights with regard to taxation. By way of distinction, I think it's increasingly important that we distinguish between, on the one hand, human rights in relation to taxation and taxpayers' rights. Human rights are very specifically defined as those rights that derive from the body of international human rights law. So they start and end with the human rights instruments that are applicable in a particular country, including both regional instruments such as the European Convention on Human Rights and global instruments such as those promoted by the United Nations. And they define a very specific body of rights there. Beyond that, however, taxpayers in general enjoy a wide series of rights when they are subject to the processes of the tax system. No tax system can operate without protecting a range of rights relating to the imposition of tax, the assessment of the taxes, the collection, appeals, penalties, and those rights apply not just to individuals, but they apply to entities as well. Entities are also taxpayers, even if they are not human. The two categories are not completely separate. There is an overlap between the two. There will be certain situations where one is looking both at rights derived from human rights law and rights derived from other domestic law sources. For example, and particularly relevant to tax judges, is the issue of the rights concerned in tax appeals. And certain of those rights will be guaranteed under the domestic tax law, under the tax law itself and under administrative law, but they also fall within the right to a fair trial in human rights instruments, and that imposes certain human rights limitations. Similarly, for example, one might note that the non-discrimination principle may exist under many countries' national laws, under the Constitution, but also exist under human rights instruments as well. Why do I make this distinction there? I think it's because there is a danger, and one sees this, for example, in discussions sometimes at the United Nations, including the current discussions going on in connection with the UN Framework Convention on International Tax Cooperation. There is something of a danger of muddling up taxpayers' rights with human rights. And we have to recognize that in certain countries, the whole concept of human rights is either rejected or there are very negative views taken about human rights. And I'm not just talking about a large country to your north, but also many countries in Africa and in the Middle East. The concept of human rights is not highly regarded. But even for those countries, it is unthinkable that a tax system could operate without recognizing guarantees for taxpayers' rights. And the danger of associating them together is for those countries that reject human rights also tend to say that taxpayers have limited or no rights. It's also very important to recall that not all taxpayers are humans, and therefore not all of them have the coverage of all human rights instruments, but entities and others clearly do enjoy their rights as taxpayers, even if they are not within the scope of a particular human rights instrument. We also see sometimes quite irrational arguments through confusing these issues. For example, the argument that because companies are not humans, they do not have any rights, and therefore, for example, they are not protected with regard to breach of confidential information. It's clear that confidentiality obligations under taxpayers' rights must clearly apply to companies, even if they cannot rely upon human rights instruments. So I've come to the view that it's increasingly important to make this distinction. There are, of course, certain matters that are not covered by human rights instruments and can only be derived from other sources. For example, you won't find a human rights instrument that provides for a prohibition on retrospective tax legislation, or the ability to pay principle, or a right to a hearing before the tax authorities as opposed before the courts, or the right to be represented by a professional advisor, or the right to participate in the process of imposing taxes. Those are all rights which need to be recognized, but they will not be derived from human rights law. Having made that distinction, let me then turn to talk about the first category, and that's rights derived from human rights instruments. And I talk here specifically about the position in Ukraine. Ukraine, particularly since the breakup of the Soviet Union, has become a party to virtually all major international human rights instruments. If you look at tables produced by the UN Office of the High Commissioner for Human Rights, Ukraine has a very high record of acceding to major human rights instruments. Just to highlight a few of them, at the European level, through the Council of Europe, you are and have been for a party of many years, a party to the European Convention on Human Rights. And at the global level, you are a signatory and have ratified both of the major international covenants, that on civil and political rights, dealing with issues such as freedom of expression, freedom from torture, freedom from arbitrary detention, as well as also the Covenant on Economic, Social and Cultural Rights, which I'll say a little bit about specifically later because it has a particular aspect with regard to taxation. Those human rights instruments, when they were drafted, I don't think anyone could think that tax issues were central to their drafting. When the European Convention was drafted in the immediate aftermath of the Second World War, there were far greater abuses of human rights that were concerning the draftsman. That doesn't mean to say, though, that tax isn't relevant. Tax does come up within the scope of the application of those human rights instruments. And we have, for example, well over 1,500 tax cases before the European Court of Human Rights in Strasbourg. And those cases illustrate the way in which the European Convention applies to tax matters. Not all of the articles of the Convention apply to taxation. The right to life, freedom from torture, those don't really come up in the tax context. The articles that are most relevant to taxation are a somewhat unusual selection. The right to a fair trial has given rise to the largest number of tax cases, even though the European Court has taken a rather narrow approach to the application of this right in connection with tax disputes. But where Article 6 does apply, it applies to the entire process from the start of an audit through to the final trial before the Supreme Administrative Court. And it gives, for example, a right to access to a court and a right to a clear judgment explaining how a court reaches its conclusion. Very significant in the field of taxation is the right to privacy. We all supply a great deal of information to the tax administration, and we anticipate that it will be retained confidentially. There is a freedom from discrimination, but that's in connection with the enjoyment of convention rights, but that is usually tied together with the right to property. Taxation is an exception to the right to enjoy your property. If you did not have to pay taxes, you would enjoy more of your property, and there is a case law from Strasbourg on the exception for taxation. And strangely, in the last few years, a significant number of cases have gone to the European Court in Strasbourg over the principle ne bis in idem, the principle of no double jeopardy. And you may wonder, why on earth is that relevant to tax matters? But it's because of the possibility that a serious breach of tax regulations can give rise to both administrative penalties and criminal proceedings as well, and that engages the ne bis in idem principle. Just to make good my point that these rights are relevant to taxation, I've listed there 7 cases, most of them quite old cases now, 20 years old, where Ukraine was a party to litigation in Strasbourg over the application of the European Convention. Many of those cases go back to times before the current government in Ukraine and when the respect for human rights was not as high as it is at the present moment there. In wartime, there is the possibility of derogating from human rights instruments. And the position in Ukraine is that Ukraine has taken that opportunity in 2022 when the invasion into the main territory of Ukraine started. The Ukrainian government derogated from a number of rights under the European Convention. But interestingly, 2 years ago, the Ukrainian government withdrew part of those derogations and significantly reduced the number of provisions that don't apply. The current derogations are quite limited. They apply to Articles 8, 10 and 11 of the main convention. And you'll note that the right to privacy is one of the derogations, and that is significant in tax. Articles 1, 2, and 3 of the first protocol, and again, the right to property is derogated from, and also a derogation with regard to the freedom of movement. That means that even with those derogations, 2 at least of the provisions that are very relevant in tax are still applicable in Ukraine during wartime. So the rights to a fair trial, to the extent that they apply to tax cases, and they will apply to tax cases involving penalties, for example, and the nebis in idem principle, they have not been derogated from. So those continue to apply in Ukraine. Fair trial, for example, would give right to access to a court, right to a determination within a reasonable time. Clearly, wartime conditions may impact on what is a reasonable time, and the coordination between penalty and criminal proceedings come from the nebis in idem, where there is frankly a position from the European Court as a result of a judgment involving Norway, which makes it quite difficult for governments to determine how they should deal with both administrative penalties and criminal matters. But that's an issue for a separate discussion. Incidentally, at the same time of derogating from the European Convention, the Ukrainian government has also derogated from the International Covenant on Civil and Political Rights in the same sort of way. I wanted to flag up particularly the International Covenant on Economic, Social and Cultural Rights because there's a growing sense amongst the human rights community of the importance of tax with regard to this convention. The convention guarantees essentially the collective rights that we all hope to enjoy as members of a well-regulated community. So they're not so much individual as group rights. The right to work, the right to have fair conditions of work, the right to form trade unions, the right to receive social security, the right to have your family life protected. Significantly, the right to an adequate living standard, the right to physical and mental health, the right to enjoyment of education, including free primary activity, education, and the right to engage in social activities. The link to tax is that obviously tax is critical to any government if it is to fulfill these commitments. If the government is to provide an adequate standard of physical health or to provide free primary education, the government has to secure the tax resources for that purpose. And it's also an increasing recognition that tax can help to fulfill certain of these standards. The way that the tax system is drafted may, for example, assist educational institutions, or it may hinder them by, for example, putting additional taxes on access to schools or educational resources. And the human rights community has recognized how significant taxes in terms of the economic and social rights. Much of this is reflected through Article 2, which is the primary obligation of all countries, including Ukraine, with regard to this convention. Again, I stress that Ukraine is a party. Every state party undertakes to take steps individually and through international assistance, especially economic and technical, to the maximum of its available resources, with a view to achieving progressively the full realization of all of the rights recognized in the covenant. It is an obligation on states to use the maximum of their resources, including tax resources, in order to progressively achieve education, health, safe environment for its population. There is also an extraterritorial element. There is an obligation of international cooperation arising from Article 2, and that is both an obligation to request assistance if it is needed with regard, for example, to the tax, and also to provide for that assistance. Ukraine is entitled under this convention to require other countries to provide assistance in connection with, for example, with the collection of taxes. There is also an obligation to refrain from conduct that may impede the maximization of those resources. One might note that acts of war that interfere with the economy of a country would, amongst other matters, clearly impede the achievement of this particular covenant. The reason I focus particularly on this covenant is that it does not provide for any derogation during wartime. Unlike the other two covenants I mentioned, where there is a derogation, it was not thought necessary. Governments during wartime remain under the same obligation to provide for their population, and that includes to maximize resources. Ukraine continues to have these obligations. One of the obligations is to provide a periodic report on Ukraine's steps to fulfill these obligations. Like many countries, the reports are generally overdue. Ukraine's 9th report was due in October 2024. It has been postponed, but at some time the Ukraine will need to report on, even during wartime, how this international covenant is still being fulfilled. I think that's all I wanted to say about the human rights instruments. I want quite quickly, I don't want to take too much time, to talk about the other side of the coin, and that is taxpayers' rights. Taxpayers' rights are those that do not derive from human rights instruments, but they derive from a variety of other sources. They derive from constitutional law, and I wouldn't even attempt to make any comments about the Ukrainian constitutional law. This is obviously something of which you are all very well aware. They derive very much from the tax laws. So the Ukraine tax code contains a number of rights for taxpayers. They derive from administrative law. Many of you are administrative judges. You will know that the tax officials are part of the civil service, and they may derive also from specific laws on taxpayers' rights. I understand that Ukraine does not have a taxpayers' charter, but that there are a number of rights for taxpayers included in the Ukraine tax code. To a limited extent, rights for taxpayers also may derive from regional laws. When Ukraine joins the European Union, there will be various provisions that will be relevant. For example, the EU Charter of Fundamental Rights that applies to all EU member states and will therefore apply to Ukraine when its membership is confirmed, also contains a number of provisions relevant to taxpayers' rights. And there's, to a certain extent, certain protections under public international law, including, for example, the non-expropriation through the tax system of the assets of non-nationals and non-discrimination in connection with non-nationals there. The whole area of taxpayers' rights is relatively well developed in most countries. I can't think of a country that could operate a tax system if it didn't have a system of appeals, systems for protecting confidentiality. The real issue here is the practical protection of taxpayers' rights. And here I would just, in a sense, do a little bit of advertising, if I may. 10 years ago, the International Fiscal Association, and Professor Maisto, who is going to follow me, was the president of the IFA. They carried out a survey on the practical protection of taxpayers' fundamental rights. That has led, I'll come back to this point about the different areas we looked at, but it led to the establishment of an observatory on the protection of taxpayers' rights. And if you wish to find out any information about how in practice taxpayers' rights are protected, I do strongly recommend that you consider looking at that website there. It's a free access website of the IBFT in Amsterdam. It's been updated now to 2025, and it will tell you how taxpayers' rights are protected in practice in something like 50 plus different countries where we have national reporters who report on the protection of taxpayers' rights. There are also now regularly annual conferences on taxpayers' rights. The next one is to take place in late July in South Africa, in Pretoria, and it's going to focus on taxpayers' rights, social justice, and political will in developing countries, there particularly with a focus on Africa. So far as those rights are protected in practice, I wanted to have a little time just to perhaps focus on the pressures that war may place on the practical protection of taxpayers' rights. I rather rushed over the slide, but in preparing the IFA report 10 years ago, we identified some 13 different aspects of the relationship between the government and the taxpayer. And we discussed how each of those aspects is protected. Now, how war influences that is not an issue that I think has been studied. Happily, in Europe, this has not been an issue since the Second World War. And so what I'm going to say here is largely speculative, but these were the thoughts that occurred to me that may relate to practical protection under wartime. The first stage of relationship between the tax administration and the taxpayer is to identify the taxpayer and to communicate with them. That is a confidential communication. It's protected by privacy, but it's also extremely important that there are protections against impersonation or particularly against hacking. And in the context of a war against Russia, I would have thought that a particular factor here is additional safeguards against malicious hacking. We in the United Kingdom are not exempt from hacking activities of confidential databases by malign actors, and this must be a particular issue with regards to the situation in Ukraine. I would have thought, and this is a general issue, the circumstances of war mean that meeting obligations of communication within normal time limits are very difficult. Populations are displaced, persons are on military service, and it will therefore be necessary to extend many of the deadlines and take a more permissive approach towards taxpayers' communications. The same is true, I think, of assessments, that deadlines will need to be somewhat more flexible to meet the exigencies of war, and you have the particular problem of a substantial displaced population, including a large population that has temporarily moved to Poland, to my own country, and to other countries, and so it will be necessary to adjust the normal process of assessment to take account of a displaced population. Even in wartime circumstances, maintaining confidentiality of taxpayers' data is a crucial issue. Taxpayers are asked to provide a great deal of personal information. They will not do so unless that is protected, and that's particularly significant, I've said, in border areas or areas that may come under military control from an occupying power. The danger that information that is confidential one day is accessible to a malign authority the next, and procedures need to be in place to destroy data before that's accessed by a malign actor. normal audits of taxpayers will continue during wartime, but again with extended deadlines, and what we've called intensive audits, that's audits of taxpayers who may be involved in tax evasion. They are particularly important in wartime because the circumstances make it even more crucial that governments can collect their taxes, and more opportunities exist potentially for tax evasion. As we said earlier, the appeal process will continue. Judges will continue to sit even in the circumstances of wartime. But again, the circumstances require a flexible approach to deadlines and generally a greater flexibility in the process of hearing appeals. The imposition of sanctions for failing to meet tax obligations. On the one hand, it's important to preserve the flow of revenue to the government, but on the other hand, to accept that there may be circumstances where taxpayers have had difficulty meeting their obligations and should not face administrative sanctions. So a greater leeway or flexibility, and that's true equally of the enforcement of taxes. Cross-border procedures include things such as exchange of information, and I think I probably don't need to tell you that exchange of information with unfriendly countries or countries that may become unfriendly should be terminated. In this country, we have terminated exchange of information with the Russian Federation, and we are also very well aware that in other countries, information may be sought for purposes that are potentially of danger because the country is a malign actor. Finally, there may be new laws that are imposed during wartime, preventing profiteering, for example, from the war. There are obligations of the rule of law and clarity in the enactment of the legislation. Revenue practice, the revenue authorities need to continue to provide guidance there. One point that has not been taken up by Ukraine in the past, a number of countries have, by way of institutional framework, a tax ombudsperson. That's a person within the tax administration whose function is to protect the position of taxpayers, and it may be that under the circumstances of war, such a person is particularly necessary. And finally, the last area that we looked at, and I'm sorry this has been a rather rushed review, is the whole new area of the use of artificial intelligence. As we've seen in connection with drone technology, war increases the speed of change, and it may well be that under the circumstances of war, the introduction of AI in tax administration in Ukraine is also accelerated. Overall, and I think earlier speakers have mentioned this, it is important to maintain the balance to protect the revenue of the country on the one hand to fund the war, and on the other hand, the need to recognize the special circumstances under which the tax system is operating, and in that to maintain taxpayers' rights, as well as those human rights that have not been derogated. So that leads me finally to my concluding comments. A very obvious point, the operation of the tax system doesn't cease during wartime. It has to continue, but equally, the importance of protecting taxpayers' rights doesn't go away. Human rights instruments still apply, except insofar as there is a derogation, and I've identified those derogations that apply to Ukraine. Overall, the protection of taxpayers' rights is crucial to preserve confidence and trust in the tax system and the government. War will end, and the population needs to have trust in the tax system, trust in the judiciary, and trust in the government. And it's important to maintain that during wartime. There is a balance between effective tax collection and protection of taxpayers' rights, but it's important that taxpayers' rights and human rights are not forgotten in the wartime context. In a sense, it's very sad that we should be having to consider these issues, in a wartime context, but I hope that my comments have perhaps sparked some interest and some thoughts amongst the audience. Thank you very much indeed for listening to me, and I'll stop sharing my slides now. But thank you again for the invitation.
Вельмишановний професоре Бейкер, ми щиро дякуємо за
Dear
вашу
Professor Baker, thank you very much for your interesting and fundamental presentation, which once again demonstrated convincingly for us that even in the period of war, the human rights remain the foundation for a democratic state, and looking for just balance between the interests of the state and rights of taxpayers is one of the key challenges in the modern law. And we, dear participants, it will be right if we say Professor Baker that his great phrase that human rights and taxation are not oxymoron, and your article is the roadmap for us. All tax judges know this article, and for us it is very important that today you were with us, and we believe that next time we will welcome you offline in our Ukraine. Mr. Vyacheslav, the floor is yours.
Також дякую шановному пану професору Філіпу Бейкеру і особливо так само
thank esteemed Professor Baker, and special thanks for the conclusions that he made, that it is very important under conditions of martial law to ensure balance between effectiveness of tax collection and trust, because issue trust is red line now, important issue, and in wartime especially important. Thank you very much indeed. Now I have a great honor and pleasure to invite our next speaker, esteemed Madam Nina Poltorak, President of the Second Chamber of the General Court of the European Union, Doctor of Law, Professor. And I want to mention that Nina Poltorak belongs to the range of European judges that formed the framework of European law. She was the head of training judges in the Jagiellon University, developed the structure of administrative justice in Europe. And for us, important is both theoretical and practical experience. Esteemed professor, please, the floor is yours.
Thank you very much. Can you hear me right now, and can you see me? Great. Thank you very much.
Yes, we can.
Thank you very much for the invitation for this conference, which I find particularly important and particularly interesting because it invites us to reflect on how the justice system and public administration function during times of crisis. And I'm really happy that I can speak after Professor Baker, because he already set the scene of the fundamental rights in international law, and I would like to focus on the EU law, because I think that the question that arises, which is the most important in view of the theme that I've chosen, that means the effective judicial protection in EU tax cases, the question that arises is whether crisis situations may justify modifying the standards of legal protection afforded to the taxpayers. And my perspective is, of course, limited to the European Union law, and I'm listening with great interest to the experience of Ukraine, of course, which are both unique and in a way extreme. However, I have to add that the European Union also has experienced a series of crises, including the global financial crisis, the COVID crisis, the energy crisis, and also the economic consequences of Russia's invasion of Ukraine. And those events have required governments of the members of the European Union to react rapidly and introducing exceptional fiscal measures. But first, I would like to outline the legal background of the effective judicial protection in EU tax cases. As we all know, European Union is based on the rule of law and respect of fundamental rights, which are among the values listed in Article 2 of the Treaty of European Union. Those values define the very identity of the European Union as a common legal order. Thus, the European Union must be able to defend those values within the limits of its powers as laid down by the treaties. And in the recent case law, the Court of Justice just confirmed that those legal values are not only declarations, they are also binding legal obligations. And that means that they can constitute even the grounds for the European Commission action concerning the infringement of the obligations of the member states towards the European Union. And one of the essential components of the rule of law that is prevailing in the European Union is the principle of effective legal protection. Originally, that was the principle rule that was developed in the case law of the Court of Justice, and now it is the general principle, still general principle of the EU law, but is right now recognized directly in Article 19 of the Treaty of European Union, which requires member states to provide remedies sufficient to ensure effective legal protection in the fields covered by Union law. And it's further guaranteed, more specifically, in Article 47 of the Charter of Fundamental Rights, which secures the right to effective remedy and to fair trial before an independent and impartial tribunal. Of course, the Charter contains also additional safeguards to effective legal protection. First of all, Article 41 guarantees the right to good administration, requiring tax authorities to act impartially, fairly, within a reasonable time. And this is a very important fundamental right that is provided for in the Charter, taking into account that not in every member state the right to good administration is recognized as a general principle of law. And we have it codified in Article 41 of the Charter. And in the financial context, Article 70 of the Charter protects the right to property. I have to mention also Article 42 of the Charter, which is also very important in tax cases, which provides that any limitation of fundamental rights, that includes also effective judicial protection, must be prescribed by law, pursue a legitimate objective, and comply with the principle of proportionality. What is also important is that the Court of Justice has consistently held that member states must respect the rights enshrined in the Charter whenever they act within the scope of the European Union law, and more specifically when they implement the EU law as provided for in Article 41 of the Charter. That is also interesting to see that the first case in which the Court of Justice addressed the definition of the implementation of the EU law on the basis of Article 51 was the VAT case, when the court asked about the application of the Charter towards the sanctions, criminal sanctions for the VAT rules infringement. And in this case, Ackerberg-Franson case, the court confirmed that even those sanctions, criminal sanctions, when they are used to sanction the application of the EU law, the actions within the scope of the EU law, they also are covered by the rights and freedoms coming out from the Charter. In addition, of course, several general principles of EU law are important during periods of crisis. First is the principle of proportionality, not only the one that is provided for in Article 52 of the Charter, but also, more generally speaking, the principle that requires any emergency tax measure to be suitable for achieving legitimate objective, and not to go beyond what is necessary to achieve it. Second, it is the principle of legal certainty. which requires taxpayers to be able to foresee the legal consequences of their conduct. Third, there is the principle of the protection of legitimate expectations, which protects taxpayers who have relied in good faith on existing legislation or established administrative practice, unless there is overriding public interest, which justifies any divergent measures. And finally, member states, as a rule, must protect and respect the principles of equal treatment and no discrimination, regardless of whether tax measures are adopted under ordinary circumstances or in response to a crisis. But coming back to effective judicial protection or legal protection, it constitutes one of the most important guarantees for taxpayers. That means, first of all, that administrative decision of tax authorities must be subject to judicial review before an independent court. And whenever the court, which is of course at this stage the national court, whenever this national court has doubts about the interpretation of the EU law, this national court may, in some cases must, submit preliminary reference to the Court of Justice under Article 267 of the Treaty of Functioning of the European Union. This mechanism is very important. It provides for the uniform interpretation of the EU law and prevents any tax measures from escaping judicial scrutiny. Of course, the right of effective judicial protection also includes some procedural guarantees. The most important probably is the right to defense, which includes also the rights to be heard. Those principles form part of general principles of EU law and apply even where national legislation does not expressly provide such protection. There are also other procedural guarantees concerning, for example, the evidentiary rules. About those rules, we have many case law of the Court of Justice. And even if the member states are autonomous in how they are regulating their administrative procedure before the administrative bodies, still this procedure must respect the fundamental rights as provided for in the Charter, and must respect two conditions which are indicated in the case law of the Court of Justice, which means the condition of the effectiveness and the condition of the equivalence. We have also extensive case law about the definition of the abuse of the tax rights. And this case law, which is complex, and there is of course no time and no need to recall it, but this case law in general states that first must be a kind of a definition of the abuse, and then that the legal certainty and proportionality rules must always be respected. I would like to mention specifically the VAT in this respect, because VAT occupies a particular position within EU law, tax law system, as it constitutes an important source of revenue both for the member states and for the Union, the European Union budget. And in this respect, we have a specific regulations concerning VAT. First, this is Article 322 of the Treaty of Functioning of the European Union, which obliges member states to combat fraud affecting the financial interest of the Union. And as we have still many fraud cases in the VAT system, this is the provision that is quite often applied towards the actions of the member states. And similarly, Article 273 of the VAT Directive authorizes member states to introduce measures necessary to ensure the correct collection of VAT and prevent tax evasion. There is an extensive case law concerning this article of the directive of the Court of Justice in general, and in This is a shortcut, of course, but this case law consistently states that such measures, which are implemented on the basis of Article 273, must comply with EU law. That means respect the neutrality and proportionality principles, as well as the fundamental rights enshrined in the Charter, including of course, the effective legal protection. I must add that the war in Ukraine created another unprecedented challenge for the European governments, European Union governments. Many member states introduced extraordinary fiscal measures intended to finance support programs. And although the Court of Justice has not yet delivered major judgments concerning those emergency taxes, except for case law concerning the state aid, but not specifically the tax law, a further review, which probably would be the case, this further review might examine whether those measures they comply with proportionality, legal certainty, equal treatment, and effective judicial protection principles. And just to conclude, emergencies test the resilience of legal systems and their ability to reconcile the public interests with the protection of fundamental rights. Emergency fiscal measures remain subject to the fundamental values of the European Union and to the general principles of EU law, including legality, proportionality, legal certainty, and effective judicial protection. At the same time, crisis situations may influence the interpretation and balancing of those principles. Courts, and especially national courts, together with the Court of Justice, must therefore reconcile and balance two equally important objectives: protection of public interests during exceptional circumstances and safeguarding the fundamental rights of taxpayers. This balancing exercise lies at the heart of the case law of the Court of Justice and reflects the European Union's commitment to maintaining the rule of law, even in times of crisis. Thank you very much. That was really in a nutshell, but I hope that that can give you some basis for questions or thoughts. Thank you very much.
Дякую, шановні пані Ніно.
Thank you, esteemed Madam Nina. Special thanks to you for participation in this event, for your support, for your theoretical conclusions that you offered. I want to mention what you said, that, among other things, Ukraine should abide by principle of legal expectations of taxpayers, taking into account urgent public interest that the country has. At the same time, one should mention that even in condition of war, Ukraine often faces the issue, limits of the red lines regarding urgency of public interest. And it seems to me what you offered, very clear possibility for resolving it. Two words: effectiveness and equivalence. Special thanks for this focus. And now I give the floor to Natalia Blaszewska. Thank you. With great pleasure, I listened to presentation of Nina Poltorak, remembering my students' time. This is your monograph book. It is with me, and I believe that quite soon you shall not only read your articles as a judge of the country, that a country on the way to Euro integration, but we will be full members of EU and will avail of your experience and case law. What is especially important now, you recollected very important principle, as Vyacheslav mentioned, that we need right now in everyday work. And now Dear colleagues, I have great pleasure to invite our next speaker, esteemed Professor Maisto, who is one of the most influential person in international taxation law as the president or honorary president of International Fiscal Association. Professor Maisto had joined Organization of Modern Architecture of International Tax Law that we have now. Apart from active academic work and lawyers' work that unites 117 countries and 20,000 experts, Professor provides active consultation to government of Italy for implementation of tax reform. His knowledge and his experience are valuable for us. We are thankful to you for being with us for many years and hope that in the future you will join us offline. Your today's topic is especially important. It pertains to one of the most biggest challenge, taxation in occupied territories. So the floor is yours.
Thank you very much. It's a pleasure to attend and make a presentation this conference. Let me just share the screen. And I believe that you can see the screen from the start. 1 second. Can you see the screen? Very good.
Yes,
So
yes.
thank you. So thank you again for the invitation. It will be a pleasure also to accept the invitation to attend in person at one of the events that you will organize. So my subject today is taxation in occupied territories. And I wish to say that the topic is relevant not only with regard to the period of occupation, but also when a war comes to an end and there is a need to establish if the occupying, let's say, forces have observed international law. There are certain obligations during the period of occupation which have to be considered also after the occupation come to an end. And basically, there are rules which are shown here on the screen. Basically, 3 important rules which have to do with the regulations of the law of war, which is a treaty, basically the Hague Convention of 1899, amended in 1907. And basically, we have 3 rules which, although Ukraine and Russia are part of this convention, for different reasons. One, because it's signed at that period, and in the other situation, because of the ratification and acceptance lately, even in 2015. They are part of customary international law, so regardless of ratification. And so we have 3 provisions which have to do with taxations and also the rights and obligations of the occupying power in that period and the ramifications after that period. We have Article 43, which basically says that there is a power and the obligation to administer the occupied territory and to make changes to legislation only when there is a necessity to do that. And then we have Article 38 of the regulations, which is related to the activity of collection of taxes and assessment. And then there is a third provision, which is very important not only for the period of occupation, but also after the occupation. Namely, that the provision says that if, in addition to the taxes, which are the taxes which have been levied in the occupied territory prior to the occupation, the occupant levies other money contributions, then that will be done only for the needs of the army or for the administration of the territory. So we have three rules, and we have to establish how these rules operate, what restriction they create, and what rights, which rights can be considered and invoked when the occupation comes to an end. Basically, we can divide the say areas and subject to be covered by the three provisions. They do not overlap, at least in my view, and based also on case law and literature, which has focused on these provisions. The first one, Article 43, has to do basically with the obligation to administer the occupied territory, and obviously to avoid drastic changes to current and pre-existing legislation. And here I will make a few examples of situations which did arise in the past. The provision relies on the principle of proportionality, particularly. So the first point is that regular and routine changes to taxation legislation is regarded to be a legitimate behavior by the occupying state, but might happen also in a period of non-war. Legislation, tax legislation does evolve over time. It requires ordinary changes that may include the decrease of tax rates or increase of tax rates insofar as such increases as decreases are reasonable. Also, it may include a move from territorial to worldwide taxation, and that might be a change which may be required in order to avoid the situation where assets and income is shifted outside the territory, but also there might be a move from worldwide taxation to territorial taxation, because in the period of war, then most likely the activities outside the occupied territory are not possible. Abolition of taxes is also something which has been considered in the past, and that might be considered not legitimate behavior. There are some prior situations in which the occupied country has established a custom area, so no custom duties with the occupying territory, so a situation which would permit free movement of goods without the levying of custom duties between the occupying and the occupied territory. That is considered to be non-legitimate and might give rise to rights. Those violation of international law might be pursued once the war comes to an end. And then we have also suspension of taxes in some situations. I'm referring particularly to the situation in Iraq, which was considered under the Hague Convention, where for a limited period of time, not the collection of tax, but taxes were suspended in order to redetermine and reconsider tax legislation. Elimination of discriminatory rules, and that is also one aspect which was considered in previous situation. And of course, one of the areas which have been considered in the past is a total change of existing legislation at the time of the occupation. There is one particular case which I can mention has to do with the introduction of VAT in Palestine. Several years ago, Israel introduced VAT in Palestine. The case was brought before the Supreme Court of Israel, and the claim was indeed a violation of Article 43 because the introduction of VAT in that territory was not regarded to be necessary in accordance with Article 43, because the economic environment of Palestine did not suggest such a drastic change, and therefore the new measure was regarded not to be necessary, and on the contrary, to be contrary, let's say, to the benefit of the occupied territory. This is just to give an example of the way the provision was interpreted in the past. Then we have Article 48. So whilst Article 43 makes reference to the obligation to administer and to the obligation not to change legislation if not strictly necessary, Article 48 has to do with collection of taxes. And the collection of taxes and also the assessment activities have to be applied in accordance with the rules which were in force at the time the occupation started. And more importantly, the provision makes reference to an additional obligation, namely that the revenue generated by the taxes has to be used solely for the administration of the occupied territory. So the revenue generated cannot be used for other purposes, but only for the administration of the occupied territory. And this provision is very much related to Article 49, which you can see in the right part of the slide, which does make reference to what are called contributions. And that I think is this Article 49 is a very important provision, especially for the post-war period, because the provision says that in addition to the taxes mentioned in the above article, meaning the taxes which were levied before the occupation and that will continue to be levied before the occupation, and whose revenue will be used solely for the administration of the occupied territory, then the occupant may levy money contributions, they are not called taxes, in the occupied territories, and only for the needs of the army or the administration of the territory. So the prevailing opinion is that these contributions, which from time to time have been used and applied in the period of war, they are not taxes, but they are similar or have the same value of monetary requisitions. So sort of expropriation on either individuals or companies or communities, such as provinces, municipalities, and those levies which can be applied and can be used for the need of the army have, after the period of war, to be restituted to the occupied territory. So they are not, as they are not taxes and they are considered to be expropriations. Once the war comes to an end, there is an obligation by the occupying territory to restitute to the occupied territory the amounts which have been levied by the occupying territory. We have some case law on this particular situation. You can, the first case I mentioned is the one regarding the introduction of VAT, which has to do with the introduction of new taxes. But the second case is actually an Italian case. I report it not because I am Italian, but simply because it's the only one case which dealt with the subject of the application of Article 48, and that provides a clear view of the application of this rule. Basically, during the occupation, the German requisitioned brandy stored in warehouse and granted an exemption from excise duties. So this was not a real, let's say, requisition in terms of a contribution requested, but was a change of legislation which basically affected negatively, reduced the resources of the occupied territory. And after the war, the taxpayer asked basically the former occupied territory asked and claimed the application of Article 48 in order to obtain the restitutions of the amount equal to the duty which was not applied. The same principle may apply in the situations in which contributions are being applied during the occupation. And after the period of war, such contributions, as they cannot be regarded as taxes, but they are equal to requisitions and expropriation, may be requested to the occupying country. And as I mentioned, this is the prevailing view. I have made reference, just for the sake of time, I will not address those points, but I can provide references to prior case law and situations, particularly the Iraqi occupation in the year 2003 and 2004, and the attitude of the US coalition, and so the provisions which have been introduced in those years and which raised the issue of the compliance with international obligations which are contained in the regulations of the Hague Convention. The same for Western Sahara in 1975. This has to do with the opposite situation where local legislation is totally changed, providing for exemption, and those changes were basically challenged after the occupation and are still ongoing. So I believe that the short message that I want to forward is the importance of monitoring compliance in the occupied territories of Article 43, 48, and 49 of the regulations, not only for the period of the occupation, but also for the post-period of occupation, in order to permit a recovery of amounts due to the illegitimate behavior of the occupied territory. So with that, I complete here my short presentation, and I wish you a good continuation of the conference. Thank you very much.
Шановний професоре Маїсто, ми всі дуже уважно слухали ваш виступ.
Professor Meister, we listened to your presentation attentively, the cases that you demonstrated. We as lawyers, we understand the complexity of combining international law, taxation law, state sovereignty, and the conditions of occupied territories. And for us, it is very important that the aggressor that we have to fight with at the moment, that the aggressor reimburses fully all the damages caused to us. At the same time, us, we stay democratic and legal country. We always adhere to, and we adhere to the provisions of international law, rule of law principles, and this differentiates Ukraine from the wild aggressor that we have to fight with at the moment. And as always, the intelligence differentiates us. Our country is democratic and legal, and we're different from our uneducated enemies. So thank you very much for thank you very much too. And when we have international analysis and discussion of this issue, we would like to dedicate special attention to the fact that occupier, our enemy, has to reimburse all the damages that were caused for recovery of our country. So thank you very much, Mr. Vyacheslav. Thank you, Natalia. The professor, let me thank you sincerely for selecting the topic of presentation, which is very important, and at the same time it's very sensitive for our country and our society. It is obvious that those issues that were raised by you, they will be the subject of discussion at the theoretical and practical level. Our country will have to go back to those matters once again, and so they will be subject of comprehensive discussion and review. Once again, thank you very much to you. And let me give the floor to Mr. Silvan Moran, President of Association of European Administrative Judges, Doctor of Law. And also to mention that
I want to give the floor to esteemed President Silvan Moran. He is one of the most important representative of administrative justice in Europe, defending independence of judiciary. His activity in the Association of European Administrative Judges facilitated promotion of new mechanisms and achieving judicial justice in modern challenges. Esteemed Mr. Silvan, the floor is yours.
Thank you very much. I will try to display my presentation from another device. I will see if it looks, if it works. I think I can't. No.
Sylvan, we will try to do it by our technical assistant.
Okay, if you can display the presentation, it's very good. It would be perfect. Let me organize the documents. So I propose you to speak about a case study, which is France during the First World War. As you know, France has been engaged into many wars, but it seems that related to the situation of Ukraine today, maybe the First World War is the most relevant. And I would try to provide something synthetic and comprehensive. It's interesting to bring what I would call a macro perspective, a perspective from the full country. So if we are at the start of the war, before the war, we can say that France is, we could say, financially and fiscally very conservative country. We could say it's old-fashioned. And most of the tax framework comes from the French Revolution and has very little evolved since then. So public revenue is 80% from indirect taxes and 10% from real estate taxes. Then also France has a very strong currency based on gold, and it has been stable for more than a century, since 1803. In France, at this time, the bourgeoisie is very hostile to taxation, and we have also a large class of rentiers, who are people living on rents, on permanent rents granted by the state. And finally, there is no income tax, and therefore at this time, France is in a different situation compared to the UK and Germany. Then if we come to the beginning of the war, so the next slide, we see that the population of France is approximately 40 millions. Exactly. The slide before. No. Before. Yes. Before. Exactly. So that's the right one. So the mobilized male population, adult male population, is 7 million for the mainland. So you see that it's a very large part of the adult population. And at the end of the conflict, the number of deaths is 1.4 million for the military plus civilians, and 1 million permanently injured. And that has been the case, for instance, for the father of my grandfather, who was wounded in the Vosges. But at this point, it's statistical for a French person to have a relative who has been killed or injured during the war. From an economic perspective, approximately a quarter of the mainland territory is occupied by Germany or is the front line. The Western Front is in France and in Belgium, and that raises economic issues because this part, the northeastern part, is the industrial heartland of France, especially the steel industry, and it's also very important for agriculture, especially wheat and sugar. And so from the start, the French economic situation is hindered by the war, and France will have to finance a war and its huge expenses while having an economic situation which is diminished. Moreover, most of the mobilized soldiers are farmers, so they can't participate to the harvest. The war starts in the summer, in the time of the harvest. So from the start, it's difficult. Then France comes naturally to the policy mix of public finance in wartime. It's the next slide. And so there is a policy mix to find between taxation, debt, and monetary creation. And there are policy debates on whether, if we choose tax, it should be new taxes or it should be raising existing taxes, whether it should be extraordinary taxes for extraordinary expenses or raising permanent expenses. And so you have argument pros and cons. You can say families are already paying the price of blood. There is economic hardship, so it's not the time to raise taxes. Or you can say that it's a patriotic moment. Taxpayers understand why the taxes are raised for and are keen to comply. So it's a good moment to raise taxes. Whereas after the war, they will be more selfish and they will make more tax avoidance. And or you can say, oh, but during a war, people are looking for safe investments. State bonds are very safe investments, and therefore it's a good moment for issuing war bonds. All in all, so France chose the very highly debt over taxation. Whether it was good or bad, it could be discussed, but it's a little bit different from other countries, and therefore the public debt explodes during this period 5 times, going to 117% of GDP, provided that the state permanent resources at this time were far lower than it is now. So and then concerning debts, you have two choices: either domestic debt and war bonds, or foreign debt. And therefore, France chose foreign debt as well and become indebted to the UK and to the US. And the First World War is the time during which there were massive gold transfer from France and the UK to the US. And so it was the starting point of the domination of the dollar as a currency and the domination of US economy at the world stage. If we come to taxes, so we first see that there is a tax exoneration, a stamp exoneration for military mail. So there are a lot of soldiers. They need to keep contact with their families through mail, and therefore all mail from and to the front is exonerated from stamp. On the other hand, this mail is subjected to military censorship and can be censored. Then the natural outcome at this moment is the introduction of the income tax. So the income tax had been into discussion for a long time. It's not the war is not at the origin of the introduction of the income tax, but it's the right moment to introduce the income tax. And so the income tax stays the same nowadays. It's on natural persons. It's a tax by household and not by individual. It's synthetic, meaning that all revenues, all incomes are taxed and not depending on only on the nature of the revenue. And progressive, the higher the income, the higher the taxation rate. And the main source of inspiration from the French income tax is, very paradoxically, the German income tax, the Einkommensteuer. And therefore, at this time, it was already understood that the source of inspiration was paradoxically the German time, where in a period during which the French were very nationalist, and so you had arguments such as the Prussians are the slave of their state, whereas we are the free French, and therefore we should not have an income tax. But if you are in a war situation, you need to find new resources. The finance minister who introduced this income tax was the victim of a very violent smear campaign, something that we can't even imagine nowadays. And he was even convicted for collaboration with the enemy, not for the income tax, of course. Then we have a creation of the exceptional contribution on war benefits a bit later. So targeting war profiteers and especially public procurement, which is totally out of control at this moment. And this contribution is very modest. It does not finance the war. And moreover, auditing the companies and assessing the income takes time, and therefore most of the product of this tax is accounted after the war. However, what is interesting is that if you want to tax war benefits, you need to assess what is a benefit and how to determine legally and in contability what is a benefit. And therefore, it's introducing a pattern into the French taxation system, which will be fruitful for the future. And finally, you have a set of taxes, control taxes related to food rationing and food supply in order to provide food to the population. And it worked more or less. Then if we come to the legal developments, my next slide. We have case law. And these case law are among the great cases of the administrative case law. And why? You have in France a handbook, which is labeled a canonical handbook labeled the great cases of administrative case law. And so therefore these cases are canonical. French law students have to study these cases if they want to pass this exam. And on approximately 100 cases, 3 of them are from the First World War. The first one is the Arias case. And so Arias case is what we call the theory of exceptional circumstances, meaning that in times of absolute necessity, such as a war, the executive power is entitled to set aside legal requirement, to set aside statutes by parliament. So that is very strong, especially provided that the French Third Republic was a parliamentarian regime, a ultra-parliamentarian regime. This case has been commented by a leading scholar in administrative law named Maurice Oriou, and we see that later the German lawyer Carl Schmitt was inspired by the Arias case when he set his own theory of a state of exception. Then the second case is the Regnault des Rosiers case in 1919, and it's the explosion of an ammunition depot, an ammunition storage, and the neighbors are the victim of this explosion. And it's a case introducing administrative liability without tort, because it is very difficult for a court to state that there is a tort to create an ammunition depot in wartime. Therefore, the state is liable without tort because the neighbors, they had a financial burden and human burden which exceeded the burden that all citizens must bear in times of war, and they are entitled to damages. The third case, students tend to like the third case, the Dame Dole and Laurent case, which is about restricting the access of prostitutes to a military naval base in times of war again. And so prostitution was legal at this time, but the restrictions are understandable for public order and also to safeguard military information and to protect military intelligence. So it's a case about enlarging the powers of restricting trade and activities during wartime. This is for the case law. And then concerning the law professor, the academic aspect, they were also engaged into the conflict. Many of them were mobilized, were soldiers. And also as academics, they were engaged into la guerre du droit, or the lawfare against Germany, defending that Germans are authoritarian and barbaric, and therefore the German legal field is vitiated in its principle, whereas the French stand up for democracy, peace and justice, and so on. We can't say that this guerre du droit was very decisive for the victory, but that was the patriotic commitment of the law professor at this time. And you have an important book about public finance, law and public finance, by the professor Gaston Gèze, who is an emerging scholar on all this issue of public finance. He's into law, he's into economics, he's into finance, and therefore somehow a star is born. Maybe that if he was here today, he would make a far better presentation than mine. So if we come to the next topic, so from the French domestic issues about financing the wars, after the peace, during the peace and after the peace, it turns into an international issue through the questions of war reparations. At this time, France is victorious, but is ruined. Its economy is in ruins. The war fatigue is very high. Soldiers and their families, they speak of like they are the last of all wars. And what has been promised to them by politicians during the war is that, okay, now the times are hard, but later Germany will pay. L'Allemagne payera. And so that's the all the issue of the war reparation discussed at the Treaty of Versailles. And at this time in Versailles, the French are the hardliners. They want to impose very harsh conditions on Germany. And they manage with other countries, such as Belgium. They managed to introduce a provision about the responsibility of Germany for damages and losses during the war, and it's the basis of war reparations. So the famous British economist John Maynard Keynes participates to the negotiation as an expert and drove his analysis of the negotiations in a book which has been published at a very large scale, The Economic Consequences of Peace. And basically, in this book, the French are the bad guys. They want to impose harsh conditions on Germany, whereas if the Allied powers had been more lenient with Germany, they would have rebuilt and would have been more peaceful. However, it is very debated even today. Some say that Germany was able to pay but didn't want to pay. Some say that the UK was too greedy and wanted too much, whereas it was not in the same situation as France. And some others say that the US profited from the war, from the Allied powers, France and the UK, and should have compromised on their own debt coming from France and Germany, because the project of France was to get the war reparations from Germany in order to repay the loans to the UK and the US. However, if we come to the next slide, Germany was not keen to pay the war. No, the next one. To pay the, yes, exactly, the war reparations, which was very disappointing for the French, because in the former war, the French-Prussian War of 1870, France paid the war reparations and paid cash in gold. At this time, it was the largest financial operations, but the Germans, after the First World War, did not return the favor and basically stopped complying with war reparations. So, as a consequence, the France and Belgium decided to occupy the western part of Germany, the Ruhr, the western bank of the Rhine, which is the heart of the industrial power of Germany, in order to try to get payment in kind. However, it was a failure. The production stopped and they didn't get payment in kind. It was even more destabilizing for the French and Belgian economies. And at this time, also, France understood that it was getting diplomatically isolated, especially vis-à-vis the UK and the US, which was very frightening, because the whole point of the French foreign policy after the First World War was to contain Germany in order to avoid being attacked again. And so they understand that they are isolated and it will be difficult to deal with Germany. However, what France and Belgium succeeded to do was to destabilize the German economy and accelerate hyperinflation, and therefore they destabilized the Weimar Republic, which was not in need of further destabilization. So this issue was settled with a negotiation with Allied powers and Germany, and in order to spread payments over times. And Germany fulfilled its requirement of payments of war reparation in 2010. So at this stage, without the hope for war reparations, given the economic situation, there is no other solution than economic reforms. And it's an important finance minister, former president of the Republic, Raymond Poincaré, which engages the reforms, raising taxes. And so the marginal tax rate of the income tax comes to 72%, peaks at 72%. So you see that in 10 years, the French got from no income tax to marginal rate of 72%. Financing through a public monopoly on tobacco and matches, reduction of state expenditure, including court reforms and administrative court reforms. So the Poincaré reform of administrative courts in 1926. And finally, a monetary reform with a new form of money. And at this moment that France gets stability, economic stability again, and overcomes the difficulties created by the First World War. So to conclude, I would say that it's a history about law, about war, about public finance. It's a history of paradoxes, paradox of creating a tax to finance the war, but financing the war through debt, paradox of winning the war and losing the money. And so there is no univocal outcome or conclusion from this experience, because there is a balance to find between international relations, economic situation, political situation in a country, and so on. So it's difficult to strike the right balance. In fact, the war has a destabilizing effect on everything, and it's difficult to settle. But as you have understood at this point, there are many similarities between the French situation during the First World War and the Ukraine situation during this war. And I think that's why for the French, when they see the situation in Ukraine, it reflects their own historical experience. And therefore, that's why they tend to have naturally a lot of support and sympathy for Ukraine, because they have gone through such a situation somehow a long time ago, a century ago. Thank you very much.
Дякую, шановний пане Сільван, за таку
Thank
змістовну
Mr. Silvan for this informative and interesting presentation. And listening to you, I just draw the parallels between the way that France had to take and what we have to go through today in Ukraine, in particular in this brief period of time and tragic period of time that Ukraine has to undergo in the periods also that you covered in the period of 1917, 1921. But we'll discuss it later. And now I pass the floor to Ms. Natalia, please. Mr. Vyacheslav, I was listening attentively to our distinguished guest, Mr. Silvan, and I think just like all of us, I had the idea how important it is that all financial decisions made during the war and after the victory, they should take into account the needs and interests of Ukrainian people, because these decisions will determine the development of our country for decades ahead. And it is logical now that we move to detailed historical analysis to Ukrainian experience of statehood and I'm honored to pass the floor to co-moderate today's session, the Judge of the Supreme Court, Doctor of Legal Sciences, Mr. Vyacheslav Hulak, who is one of the founders of modern Ukrainian School of Research, Financial and Tax Law. Research by our moderator are fundamental and are mostly quoted in the area of Ukrainian legal science. So it's a great honor for all of us to listen to your presentation. Please, the floor is yours. Thank you, Ms. Natalia, for kind introduction. I'm very pleased to hear this from my colleague and almost neighbor in terms of offices. Thank you for kind words. The topic of my today's presentation is public finance and establishment of Ukrainian statehood will cover the period of 1917 to 1921. The point is, at this period, Ukraine had to undergo difficult path in establishment of own national statehood and national finance system. At the same time, in this period, Ukrainian state, for the first time in history, introduced national paper money, announced the establishment of its own tax and banking system, established a national bank, national treasury, established state's financial office, Ministry of Finance, which was called General Secretariat of Finance, and then it was renamed as People's Ministry of Finance. It's conducted active financial policy in the international level, including it's carried out a number of several rounds of negotiations, including with French Republic, which we'll mention separately. At the same time, the activities that were carried out or not carried out by the governments of Ukrainian People's Republic and Ukrainian state in financial policy, and which were planned but for various reasons were not implemented. They were one of the reasons of failure of young Ukrainian states in the beginning of 1920s. So these events have to be a lesson for today's state of Ukraine, as the experience that was gained. We need to realize the reasons and causes, and it should be additional incentive to develop ways of avoiding of something similar in the modern and future history, because the price for error, for mistakes, can be not only some political consequences, but it is the issue of independence, sovereignty of Ukrainian people, and so the issue of lives of great number of people. I would like to remind you that one of the first legal acts of Ukrainian People's Republic, which was adopted by the parliament, it was the law of 25th of November 1917 on exclusive rights of the Central Council to make legal acts of the Ukrainian People's Republic. This act envisaged that all laws and resolutions which have the force in the territory of Ukraine until 27th of November 1917, if they were not changed or cancelled by the decrees of the Ukrainian People's Republic and also laws and resolutions of Ukrainian People's Republic, they continue to be enforced in the territory of Ukraine. A special activation of activity of the government to form national monetary system. First of all, to establish the legal framework on finance, in particular on November 28th, in 3 days, the acting Secretary of Finance raised the issue of issuance of Ukrainian money at the session of the government. The Republic General Secretariat approved the mock-up of the bills, and it was decided that the bill itself will be printed in 4 languages. At the others, it will be in state language, Ukrainian. At the reverse, it will be in 3 languages of national minorities, Russian, Polish, and Jewish. Yiddish, and the acting finance secretary was commissioned to ensure the printing of the bills in one of the printing houses. And one day, the acting finance minister reported on a number of financial aspects. First, about the state of affairs with the issuance of Ukrainian money and also the foundation of Treasury of Ukraine. On 1st of December 1917, based on the proposal, the Judiciary Secretary, the government to engage maximal range of public for discussion on the draft of the future act and the budget, decided to issue popular leaflets and also extended big leaflet with explanations for the population on financial plan of General Secretariat for the next year and the funds to ensure Ukrainian money. On December 2nd, 1917, the government, based on the proposal of acting Minister of Finance, approved the laws on public revenues of Ukrainian Republic and also on the establishment of Ukrainian National Bank, the reform of Treasury, and also liquidation of existing gentry and peasant land banks by transforming them into Ukrainian State Land Bank, which had to perform its great state bank for special commissioners based on the approval of General Secretariat as the executive power in Ukrainian Republic. To develop the draft budget for 1918, on the 3rd of December 1917, all ministries received the order to circulate to the General Secretariat not later than December 18, 1917, the drafts of regional expenditures for 1918. However, because of internal disorganization in the country, this order was not fulfilled. Due to a shortage of time, I will not discuss specific regulations, some specific points, because our time is limited, and I will allow myself to summarize this historic period, the end of 1917. Indeed, we have to say that most of the laws and regulations that were adopted and approved by the Central Council remains pure declarations because of a simple factor. The point is that in December 1917, Russia started a full-scale invasion in Ukraine, and in this way, in the north and east, we had a wide front line. At the same time, in 1917, Ukraine, in the west of Ukraine and in the north of Ukraine, there was also the front line because of the First World War, and also there were armed forces, armies that were also applying to Kiev, to the government in Kiev with a request to provide food assistance, first of all to provide food for Russian army that was the so-called Western Front, because it's a well-known events that happened in Russia. Also, there's a great problem with logistics and delivery of food and all the rest. And we have to know that Kiev government, understanding the existing situation in the front, made the decision to supply food to the army, but at the same time, Ukrainian government applied to the army in the Western Front that they should influence the Russian forces, the Russian army that attacks Ukraine from the northeast. We can say that at the end of 1917, almost in all the pyramids of the border of Ukraine was in hostilities, which affects the efficiency of implementation of all those laws and regulations that were developed by the Central Council, and the efficiency of establishment of financial system was affected at the Ukrainian People's Republic. I'd like to mention in a few words that in the key summary, key conclusion made by the Prime Minister of Ukraine was the key phrase: "Unfortunately, without money, the fight is not possible." This thought was supported by the representative of Directorate, Simon Petlura. He mentioned that to find funds, we need to find any sources and capitals wherever they are. At the same time, even these difficult conditions in 1918, 1919, Ukraine managed to implement national monetary system, taxation system. The specificity of taxation system was that the key feature was prevailing of indirect taxes. First of all, excise duties. A separate type of the system was availability of a number of monopolies. First of all, bread and sugar monopoly. I have to know that sugar monopoly of Ukraine was the lion's share of revenues for the state budget of Ukraine of that period. And at the same time, although Ukraine was in difficult conditions, so the government of Ukraine under the leadership of Hetman Paul Skarpatsky managed to generate revenues, including in European banks, which also shows effective and assistant work in these difficult conditions. Understanding that my time runs out, I'd like to give the quote, a well-known Ukrainian philosopher. From that time, most of his life, he lived in the United States, Mykola Shlenkevich. He points out the negative experience. I'd like to discuss these aspects now. Negative experience of establishment of financial system of Ukrainian state. He mentioned that unfortunately the freedom and not state was a real slogan of Ukrainian democratic parties. Because of this, in Central Council there was rhetoric of freedom and not state. On the circumstances and Ukrainian side were threatened and were not leaders of the events, we were led by the events. Dear colleagues, the topic of today's presentation was offered as the ideas, just offered to us, knowing our experience, remembered our experience, so we should never allow ourselves to going forward, and today the events lead us. It's obvious for us, including after today's night, that Ukrainians are the people, nation, who realize and implement the principle that they have to lead the events. Thank you very much for your participation, Natalia. This is it.
В'ячеславе, вам вдалося неможливе. За такий короткий час так детально і так
Vyacheslav,
цікаво
you made impossible.
представити нам,
Because in such short period of
як
time,
же
you made such an
функціонувала, як
interesting
розвивалася наша
presentation
держава в
and told
період
how
17-21
our
року.
state
І
functioned in
ваші
the period from
висновки є просто неоціненними,
1917
тому
to
що ми всі маємо
1921,
запам'ятати
and
нашу історію,
conclusions
щоб
that
наше
you made
майбутнє
are also very
було
valuable. We must remember history to avoid mistakes
мали
in
місце
the
в минулому.
future.
Ми сьогодні з вами, шановні учасники,
So,
мали
dear
дуже таку
participants, today
неймовірну можливість
we
слухати
had
в першій сесії
extraordinary
доповіді
opportunity to listen many
найбільш
presentations
авторитетних
in the first
професорів.
session. The
Я не можу
most
особисто слово сказати, не лише
significant, the most
професора Бейкера,
well-known professor of the world, Professor Baker, Professor Maista, Professor Poltorak, President Meren, esteemed Vyacheslav Hokulyak. And my question, Vyacheslav, is, have we fulfilled the task set as moderator? Have we deserved coffee? I'm not going to make hasty conclusions because we continue working in afternoon. But I hope all colleagues agree that we all deserve for lunch.
Я хотів уже
I would like to say I know that Vyacheslav is quite modest, but it was so interesting to listen to Vyacheslav Koholyak. And this historic development that he described was very interesting, and he analyzed it so nicely. I got real professional class, and I thank all participants for their wonderful presentation for this first session. That was so interesting that time passed very quickly. Moderation was at very high level. Real thanks to all our guests, to Professor Baker, to Professor Maisto, because the contribution that they make into development of our country is very valuable. Thank you all indeed, and I invite you all for coffee. We come back and resume work at 2 o'clock. Thank you, Natalia and Vyacheslav. Thank Raisa, thank Vyacheslav. Thank you, Natalia. Look forward to see you at 14 o'clock.
Шановні колеги, шановна Раїса Федорівна, починаємо вчасно, так?
Dear colleagues, shall we start?
Так, 2 хвилинки починаємо.
Yes, couple of minutes waiting and we shall start.
Natalia, hello. Can you
Hello,
hear me?
hello. Is everything okay? Yes,
Perfect.
we hear you.
Everything
Hi,
is
Natalia.
perfect. Yes. Perfect.
Ми готові, так, пане В'ячеславе? Починаємо.
We shall start.
Шановні колеги,
Dear
ми
colleagues,
оголошуємо відкритою другу сесію, яку я
open
маю честь, як і
second
попередню,
session
співмодерувати з вами, шановним
that I
паном
have
В'ячеславом. Я
ordered to
сподіваюся, що наш
co-moderate
тандем
with
вам подобається.
Vyacheslav. I hope
Мені особисто
our
дуже подобається
tandem
сьогодні
was to your
співмодерувати сесію
liking.
з моїм дорогим
Yes,
колегою
I
В'ячеславом.
liked
Якщо
moderating
перша
it together
сесія
with
була присвячена
others.
історичній
If
еволюції
this
правового
session
регулювання
covered
публічних фінансів,
historic
то
evolution of
зараз
the
ми, шановні колеги,
regulation of
переходимо
public
до
finance,
аспектів сучасного
now we
міжнародного
come
досвіду
to
і до детальних
modern
практик,
time
які слід вивчати.
experience
Сьогодні особливо
and
важливо
practices of
не
different
лише аналізувати
countries.
національне
Now it's
законодавство,
important not
а й
only
вивчати рішення
analyze
інших країн.
national
Адже сучасні
legislation,
кризи
but study
найчастіше
experience of other
мають
countries
глобальний характер і потребують спільних
because
правових
that has
відповідей. Саме
global
тому
nature.
для України надзвичайно цінним є
Therefore,
досвід наших міжнародних
very
колег.
important for
І для
Ukraine
мене
is
величезним
experience of
приємством
our colleagues.
запросити до
It's my
слова
great
з
pleasure to
доповіддю
invite
одного з найбільш цитованих
one of the
вчених
most
світу з міжнародного
well
податкового права.
quoted
Вченого,
international
наукові
scholars
праці
of tax
якого
law,
та
a
висновки
scholar
протягом десятиліть
whose works and
використовувалися і
conclusions were
використовуються
for
Організацією
centuries,
економічного
for
співробітництва
decades
та розвитку,
used
урядами
in
багатьох держав та
OECD
міжнародними
countries,
організаціями під
by
час розробки
governments of different
сучасних правил
countries and by
міжнародного
international
оподаткування.
organizations when
Підручники
developing
нашого
rules of
вельмишановного звукоміра
taxation.
є
And
класичними
textbooks
вже для кількох
of
поколінь
Mr.
фахівців з
Brian
міжнародного податкового
Arnold
права.
are
Тому
used by
сьогодні величезна
specialists of
приємність
tax law the
запросити
world
до
over. It's
слова
my great
шановного
pleasure to
професора
invite
Брайана
esteemed Professor Brian
Арнольда.
Arnold.
Аудиторія ваша. І
The
дуже
floor is
дякую, що всі
yours.
ці роки ви з
Thank you
нами.
very much for being all those years with us.
Good morning, good afternoon, and thank you very much for inviting me to participate in this wonderful conference. It's a great honor for me. I have heard about the strikes on Kiev overnight, and I have followed your epic struggle against a much larger foe. And I admire your courage and resilience. And I just wish that my country and the United States would do more to help you. I'm going to see if I can share my slides. And can you see those slides properly?
Yes, we see.
Good. Okay. So my topic for today is telling you about the impact of World War II on the Canadian tax system. And unfortunately, what my research showed with respect to this topic is that I don't think it has a lot of relevance for your situation in Ukraine, and obviously the situation of Canada during World War II was very different from the situation that Ukraine is facing at the present time. During World War II, Canada was not threatened by invasion from a close neighbor the way Ukraine is, the situation Ukraine is facing now. And we were part of a very wide and strong alliance of countries during World War II. So your situation is very different, and I'm not sure I have much to tell you that will be of value, but it may interest you to see what Canada's experience was. So what I propose to do is, on this first slide here, is to give you some background information on Canada's history and governmental structure with respect to taxation as background to what happened during World War II. And then I'll talk just briefly about the changes in the tax system during World War II and the changes after World War II, which is, of course, something that you will be facing, the need to fund reconstruction. So to go back in history, Canada was originally a French colony, and then after the 7 Years' War, it became a British colony in 1763, which is, of course, not long before the United States became a separate country. And one thing I will tell you that may be of interest is a parallel between our situations is that that in 1812, which was about 20 years after the United States became an independent country, it invaded Canada, and we had Canada was not a country until 1867, but the U.S. invaded the British colony of Canada, and after a number of pretty fierce border struggles, the war was ended with a peace treaty, and Canadians like to think it's the only war that the Americans have ever lost. The classic mistake that the Americans made was that when they invaded, they thought it would be easy. They thought that Canada would welcome them with open arms, and because it would free us from our British oppressors. This is a classic mistake that many countries have made many times since. So we became an independent country in 1867 with 4 provinces, and then gradually the country expanded primarily to the west, with all the western provinces joining in the next several years, and the final province, Newfoundland and Labrador, joining in 1949. The date of the formation of Canada as a separate country was largely in response to the American threat. And after the U.S. Civil War, the provinces of Canada were very concerned about the threat of another American invasion, and as a result, we joined together. The original Constitution, once again, in response to what Canada had witnessed in the United States during the U.S. Civil War, was that Canada wanted to have a strong central government, not strong state governments the way the United States had structured the US Constitution. So the original Canadian Constitution gave unlimited taxing powers to the federal government. It had the power to levy all taxes for any purpose. And the provinces were given limited taxing powers. And as it says on the screen there, they were given the power to levy only direct taxes within the province for provincial purposes. So this basic division of taxing powers between the federal government, the central government, and the provincial governments has been a source of tension ever since in Canada. The fundamental difficulty is that in the 1860s, things like healthcare, transportation, education, all of those things were not thought to be important and did not require large sources of tax revenue. And it just shows how difficult it is to predict the future because, of course, today, those are the things that take up most of the government's revenues. The first income tax system in Canada was introduced in 1917 as a result of World War I, showing once again the impact of war on tax systems. And that first statute was even called the Income War Tax Act. It was thought to be a temporary measure because of the war, but of course we still have a much expanded income tax system. Previously, some of the provinces and even some municipalities had income taxes, but that ceased in 1917. And then, of course, the Great Depression meant that there was a greater need for tax revenues to fund social welfare services. The struggle between the provinces and the federal government ceased during World War II. So because of the necessity to fund the war effort, the federal government took over all taxation powers, and the provincial governments simply stopped imposing tax in exchange for transfers from the federal government. We joined the war 1 week after the UK declared war on Germany, and the result of that was dramatic increases in both personal and corporate income tax rates, as well as the scope of those taxes. There was also the adoption of an inheritance tax. This situation lasted for 6 years. So it lasted from 1941 to 1947 that the provinces did not impose tax. And the agreement was that after the war was over, that the federal government would reduce its tax rates by at least 10% in order to allow the provinces then room to impose their own income taxes. So just to give you an example of the impact of World War II on the Canadian income tax system, if we look at the personal income tax, you'll see that before the war, the marginal tax rate was 13.7% on income of between $10,000 and $15,000. Now that's a lot more in today's dollars than that amount is today. But there were large personal exemptions. So it basically meant that only 2.3% of individuals in Canada were actually paying income tax before World War II. During World War II, the top marginal rate was increased to 98% on certain passive income, but the basic tax rate was 69% on income, the same income brackets that before had been subject to 13.7% was 69%. And the number of individuals subject to tax dramatically increased from the 2.3% before to 50% after. And those rates remained high after the war. In fact, those rates remained high until the 1980s and 90s, which I think indicates that it takes a long time to recover. Corporate income tax, the same sort of pattern. The tax rates were relatively modest before the war, but during World War II, those rates were increased to a top rate on corporations of 53%. And once again, they remained high after the war. And the reconstruction, which is of course something that Ukraine is going to be facing, and that's not an easy period. The reconstruction period in Canada was hampered by the ongoing Cold War, and then we participated in the Korean War in the 1950s. But we had a boom, an economic boom after the war, which facilitated the reconstruction. So enormous population growth, the population almost doubling in 20 years. The demobilization of the armed forces. We had an army at the end of World War II for a small country was just over 1 million. And so reabsorbing them into society was a difficult issue. So that reconstruction period is the period in which the tension between the federal and provincial governments, which is something that Ukraine you don't have to deal with, and it's fortunate that you don't have to deal with that because it is an ongoing source of political tension. There was failure to reach agreement. Many attempts to reach a stable agreement, but they all failed. And so what happened was just a patchwork of bilateral deals between the federal government and particular provinces. And of course, you know that Quebec is a special case within Canada because it consists of primarily French language and the civil law system, as opposed to the English language and the common law system in the rest of the country. And Quebec has aspirations to be a separate country. So that also adds to the tension. Then the basic system that was agreed upon in the 1960s and has been relatively stable, it's changing all the time, but relatively stable, is that the federal government, the Canada Revenue Agency, collects not only the federal income taxes, it collects provincial income taxes as well to the provinces that have agreed with the federal government. And the basic agreement is the Canada Revenue Agency collects the taxes, but the provinces have to agree to use the federal tax base so that there is harmony between the provincial taxes and the federal taxes. The only province in which that is not the case is Quebec, with respect to both the personal income tax and the corporate income tax. And it was the case with respect to the corporate income tax in both Ontario and Alberta, but Alberta and Ontario have subsequently agreed. We then had the famous 1966 Royal Commission on Taxation, and then a major tax reform in 1972. So the current situation is, as I mentioned, that the Canada Revenue Agency collects all the tax. It also includes the federal VAT, which is called the Goods and Services Tax at 5%, for a number of provinces. So Alberta has no VAT. Some of the provinces have not agreed to have the federal government collect their sales tax. The federal estate tax and provincial succession duties, one good thing that we have done is they've been eliminated. So what we have is we have no estate tax, no succession duties, but we do have the deemed disposition on death of all of a person's capital property. So as I say, not much in the way of lessons that Ukraine can learn from the Canadian experience, because that experience is tied up in our provincial federal disputes about the right to impose tax. The post-war economic boom and the long period of peace led to a gradual reduction in our spending on defense. So, as you know, the United States has complained bitterly about European nations and Canada not paying their fair share. The government is currently trying to increase the defense spending in order to meet the NATO targets. And of course, which is a parallel with Ukraine, currently our biggest threat is the United States. And there has been a lot of talk since Trump returned to office a year and a half ago about Canada becoming the 51st state. And so this is something that we're currently trying to adjust to and come to the realization that our closest neighbor that we thought was our friend and ally is no longer our friend and ally. So thank you very much for allowing me to talk to you. I wish you the very best for the balance of your conference. I'm sure it's a huge success, and in your struggles against Russia. Thank you very much.
Це ми дякуємо, шановний пане
Thank you,
професоре,
Mr. Professor, for your support of Ukraine, for staying with us during all these years. And just like in 2022, in the beginning of the war, when we conducted the conference, you were with us as well. And also today, you're with us. My dream is that the next conference, which will be held offline, is with your participation offline, so that you can visit Ukraine and experience that you have shared today, the experience of Canada, demonstrates perfectly that the war changes not only the budget indicators, but the philosophy of tax system. And for us, your position that you presented is very important from the scientific and practical perspective. So thank you very much indeed. We'd like to thank you as a professor, as a friend of Ukraine, as our friend. Vyacheslav, the floor is yours. Thank you, Ms. Natalia. Dear Mr. Professor, let me thank you for this interesting and informative presentation, and let me dissipate your doubts about the urgency of the topic that you have selected for Ukraine. Believe me, Ukraine is a young state which declared peace and consistently adhered to peace with all neighbors, and and ended up in the situation, Ukraine is interested in studying and examining best practices of every country, because each war is unique on its own, and Ukraine ended up in this unique situation. So, of course, we have to take into account best practices of all countries, including Canada. Thank you very much indeed again for sharing it. Now we continue, and let me give the floor to the head of the third unit of Finance Chamber of the High Administrative Court of Polish Republic, Doctor of Law, Mr. Krzysztof Winorski, who prepared the presentation dedicated to budget security under war threat and martial law in the Polish legal system. Please, the floor is yours.
Ми вас чуємо добре. Так.
I can hear you. Mr. Moderator, Miss Moderator, dear ladies and gentlemen, first of all, I would like to thank you for the invitation to this conference. As always, we can exchange experience and important information. The most important for me is to have exchange with you, our Ukrainian friends. I can see many familiar faces, many friends. Special greetings to Professor Igor Dashutin, the head of Cassation Administrative Court as part of the Supreme Court of Ukraine, and also Natalia Blaszewska, the judge of the Cassation Administrative Court. Our inter-court meetings and presentations at the Polish conference will be remembered by everyone. I would like to make a brief presentation about Polish judiciary system and related budgetary problems. The full text in English will be available. I have sent it to Judge Natalia Blaszewska. We have the situations, extraordinary situations caused by disasters, natural disasters, and other events that prevents constitutional order of the state, create threats for security of the citizens. Also, sometimes there is foreign threat. And there may be infringements on the rights and freedoms of individuals. In the Polish constitutional order, the issue of limitations of individual freedoms and rights do not depend on public authorities. They are identified by the Constitution, and the laws related to specific special regimes. Implementation of special regime and scope of limitations of personal rights and freedoms have to be proportional and have to be in line with the principles of Constitution as of April 2nd, 1997. These principles are subsidiarity, rule of law, proportionality, and temporary nature. The Constitution of Poland envisages the opportunity for the situation which requires the special regime, like martial law, state of emergency, state of natural emergency, to implement a special regime in Poland. There are current laws that regulate special regime, in particular the principles of activity of public agencies, and also limitations of rights and freedoms of individual. These laws are the law as of 29th of August 2002 on the martial law and powers of the armed forces, the laws of 21st of June 2002 on state of emergency, the law as of 18th of April 2002 on the natural emergencies, the law as of November 22, 2002 on compensation of damages limited to the restriction of rights and freedoms of individuals. And the most important is the law of 11th of March 2022 on defense of the country. The martial law in part of all territories introduced by the order of the President of Poland, based on the recommendation of the Council of Ministers, in case of external threats to the state armed invasion in Poland, or when international treaty envisages commitments on joint defense from aggression. Full-scale war in Ukraine created the need to re-examine the phrase military threat. What is the war? We deal with cyber warfare, and full-scale war with the use of conventional force. The state of emergency is introduced by the order of the President of the Republic of Poland, part of all the territory of the country, for not more than 90 days, in case of threat to constitutional order of the state, security of the citizens, or civil order. The national disaster regime is introduced by the decree of the Council of Ministers, not more than for 30 days in part or all territory of Poland, to prevent and manage the damage from emergencies or disasters. During the extraordinary regime, the constitution cannot be changed. The law on elections to Sejm, Senate, and local governments, the law on elections of presidents of Poland, and the law on state of emergency and martial law requires the increase of expenditures for defense, including military types of activity. The law on defense as of 2022 obliges updates all the acts on defense, including those targeted at the proper support of international finance, support of armed forces. Companies can be engaged into defense tasks which are financed at the expense of targeted subsidies, and also tasks of planning which are usually financed from internal funds. In modern history of Poland, the last martial law was the state of war in 1981 to 1984, introduced by the constitutional government. It is important that implementation of the martial law was caused not by external threat but by mass protests of workers. The Constitution of Polish Republic after 1952 did not envisage the state of emergency. The state of emergency was envisaged only by the Constitution of 1997. However, the situation looked different related to the state of emergency. It was not covering all the territory. On March 2nd, 2021, the state of emergency was implemented in border territories with Belarus in Lubelsk region. This was caused by mass migration of people from Central Asia and Africa to Poland from the territory of Belarus. The government of Poland decided not to introduce state of emergency in relation to COVID-19 pandemic. Among challenges facing the tax system in the crisis time is extraordinary needs and expenditures as a consequence. The new revenues, the increase of fiscal burden with prevention of inflation, at the same time establishing system of managing of tax bodies in a state of emergency, searching for new sources of revenues for the budget. To summarize, we have more than 1,000 years of neighborhood relations with Ukraine. From Kiev Rus to independent Ukraine, we made many mistakes in the past. We need to make conclusions. We need to think about the future and future cooperation for our people. Together we will be stronger. Together we'll overcome. Thank you very much for your attention. Thank you, dear Mr. Krzysztof. Special thanks for a nice presentation and great topic that you selected for your presentation, and special thanks for your support for addressing us as brothers and friends. Believe me that our attitude is mutual. We also have the same attitude to you. We really appreciate your support and your words. If I may, a couple of words, Igor Deshut would like to make a remark. I'm very happy to see you, Mr. Krzysztof. I remember our meeting in Poland, and the reception was very kind, and we visited Gliwice city. We remember your sincere attitudes, and me and Natalia Evgenievna and our team discussed how to organize the reception in Ukraine. We know that you take care of relationships with Ukrainian judiciary, and yeah, really concerned when we don't have the opportunity to discuss, but we'd like to thank you once again for finding time to join our event with a great presentation. It was very sincere and very kind. Glad to see you. Thank you. Thank you, and see you next time. See you next time. Thank you. Natalia, the floor is yours. Thank you, Mr. Vyacheslav. And Mr. Krzysztof, I have to use this opportunity to thank you for not just being our colleague, but for being our friend, the friend of Ukraine. And your experience that you presented is very important for us because indeed, you have touched on many important issues of security. It's interesting that you already take care of those issues, and you demonstrate to us that this is the example of something was not done by us on time. We missed the opportunity. We felt that there is tension, but we did not believe that the war may occur. And you are rightly doing this consistently, approaching security and finance and proper expenditures during the war. Thank you very much for this, and I believe that our delegation, as Igor mentioned, is visited Częstochowa and Gliwice. Thank you very much. We're really waiting for you in November in Lviv. I'm looking forward to that. And I hope to visit your court as well. Thank you very much. Now, dear colleagues, I'd like to pass the floor. We have many friends, and today's session is the session not just of distinguished scholars, lawyers, and judges. It is a session of friends. Friends who are with us all the time, and friends who are ready to support us in the right moment, who are ready to share with us their knowledge and experience. And I'm pleased to give the floor to our next speaker, the judge who has international recognition due to his deep research of taxation, tax law, a very talented lecturer of the School of Judges of Portugal. The works and scholastic research of our speaker have great significance for modern understanding of interlinkage between fiscal policy, statehood, and historic challenges. As I have to mention that our next speaker is also our great friend. So Our distinguished Felipe, the floor is yours. You're invited.
Natalia, good afternoon, dear colleagues, ladies and gentlemen. It is both an honor and a pleasure to address you today on a subject that lies at the intersection of legal history, economics, political science, and public finance. When discussing war, we instinctively think of armies, military strategy, and diplomacy. Yet, history repeatedly reminds us that wars are not decided solely in the battlefield. Behind every successful army stands a government capable of mobilizing resources. Behind every military campaign lies a fiscal system. Indeed, one might argue that the true battlefield of every war begins in the treasury long before it reaches the front line. The relationship between war and taxation is therefore much deeper than a simple question of raising revenue. The relationship between war concerns the legitimacy of governments, the development of institutions, the evolution of constitutional law, and ultimately the relationship between citizens and the state. As the sociologist Charles Tilly famously observed, war made the state and the state made war. Few sentences better summarize more than 2000 years of fiscal history. Today, in this conference, I would like to explore three main ideas. First, how war transformed taxation. Second, how taxation transformed the state. And finally, what these historical experiences can teach us as we face today's global crisis. Let us begin by ancient Rome. Rome's extraordinary military expansion was not merely the product of military genius. It depended upon an increasingly sophisticated fiscal administration. Taxes financed roads, ports, military logistics, and the permanent legions that secured the imperial borders. During periods of expansion, conquered territories generated tribute, customs duties, and new taxable populations. During periods of expansion, military success financed future military success. Yet, Rome also demonstrates an enduring fiscal paradox. Empires often build tax systems that depend upon continued expansion. Once territorial growth slows, while military expenditure continues, fiscal equilibrium becomes increasingly difficult to maintain. And so, several historians identify precisely this imbalance as one of the structural weaknesses that contributed to the decline of the Western Roman Empire. History's first lesson is therefore clear. No fiscal model built upon exceptional circumstances remains sustainable forever. Going forward, the medieval period introduced an equally important development. European monarchs possessed remarkably limited fiscal authority. Unlike modern governments, kings could not simply impose taxes whenever they wished. Military campaigns frequently required negotiation with the nobles, with the church, and even with representative assemblies of people. Fiscal necessity gradually produced constitutional development. Perhaps the most famous example remains the Magna Carta of 1215. Although often celebrated as a constitutional document protecting individual liberties, it was equally a fiscal document. Why? Because this document established that taxation required consent. The seemingly technical principle would eventually reshape constitutional democracies around the world. Centuries later, the American colonists condensed the same principle into one of history's most influential political slogans: no taxation without representation. This was not merely a protest against taxes. It was a demand that fiscal power should be constrained by democratic legitimacy. Here we discover a second big historical lesson. The legitimacy of taxation depends less upon its amount than upon the legitimacy of the institutions that impose it. Citizens rarely object to contributing towards genuine collective needs. This brings naturally to the situations when the taxation appears arbitrary, unequal, or political unaccountable. This brings us to the 18th century France. Before the French Revolution, the monarchy faced an enormous financial crisis. Years of expensive warfare, including the support for the American Revolution, had exhausted public finances. The fiscal burden was distributed profoundly unequally. The resulting crisis was therefore not merely financial. It was constitutional, it was social, and it was moral. As Adam Smith said in The Wealth of Nations, taxation should satisfy four fundamental principles: equity, certainty, convenience, and efficiency. France before 1789 violated almost every one of them. The consequences transformed world history regarding taxations. History teaches us that taxation is never simply about economics. It is fundamentally about justice. The scale of modern warfare demanded resources unimaginable in previous centuries. The two world wars required governments to mobilize entire nations' economies. This period witnessed the emergence of what economists describe as the modern fiscal state. Progressive income taxations expanded dramatically. Corporate taxation increased a lot. Millions of ordinary citizens paid income tax for the first time to fund wars. Simultaneously, governments promoted war bonds, transforming citizens into true financiers of the war. Whether through taxation, borrowing, or controlled deficits, the objective remained identical: to ensure that extraordinary expenditure served extraordinary circumstances. Remarkably, many institutions introduced during wartime survive long after peace returned. This was the basis for the new social insurance and even the organization of the modern tax administrations. Temporary emergencies often create permanent institutions, and these observations lead us to one of the most influential scholars of fiscal sociology. The Austrian economist Joseph Schumpeter wrote that the spirit of people, its cultural level, its social structure, all this and more is written in its fiscal history. Fiscal history reveals how societies organize themselves. Taxation is therefore a mirror of civilization itself. Although many countries are not currently financing total war, governments continue to confront with extraordinary emergencies. Some examples: the global financial crisis, COVID-19 pandemic, more recently, the Russia's invasion of Ukraine, and even the population aging. Each crisis raises familiar questions. Should governments borrow? Should they increase taxation? How temporary should emergency fiscal measures remain? These debates are not new. History has confronted them repeatedly. What changes are the circumstances. The underlying dilemmas remain remarkably the same and constant. Temporary taxes may even become permanent. Allow me to conclude. Wars impose enormous human suffering. They also reshape institutions in ways that often endure for generations. Every major conflict leaves behind not only memorials and treaties, but also new tax laws, new administrative structures, and new constitutional understandings. History, therefore, teaches us something profoundly important. The price of war is never measured solely in military expenditure. It is measured in the institutions created in order to finance survival. History perhaps invites us to think about if taxation is far more than a fiscal instrument. Taxation, indeed, is one of the clearest expressions of the relationship between power, responsibility, and citizenship. And perhaps that is the great lesson history has to offer. Thank you very much for your attention and for your time. I tried to be short. Thank you very much.
Дорогий Філіппе, ми з
Dear
величезною
Philip,
приємністю слухали вашу
it
доповідь.
was great pleasure to
навіть
listen to your
записала собі
presentation.
вашу
I even
фразу,
put
що
down your
оподаткування це
phrase that
відображення
taxation is
самої
the
цивілізації. Це
mirroring
дуже
of
глибока
civilization
фраза. Я
itself.
думаю, ми
It's a
ще не
very
раз будемо
profound
сьогодні і
phrase.
наступні дні
I
повертатися
think
до неї.
today and tomorrow we
Дуже
shall
чудова
come back to it
сказано, а
again.
також дуже
It's a wonderful
важливими є
expression.
ваші слова,
What is
які
also
нагадують нам
important,
про те, що
your words
історія
that remind
залишається
us that
одним з
history
найкращих
remains
учителів для
one
сучасних
of the best
законодавців.
teachers of the
Дуже
modern
нагадали собі
legislator.
цю історію
Important
чути,
is that
почитати приємно
legislators
знати.
can read this
Тому
history
щиро
and
вам дякую,
analyze
і
it.
ми
Thank
будемо
you
дуже
very
раді
much
чекати
indeed.
вас
We
на
shall be
нашій
very
наступній
glad
конференції
to
в
see at our
листопаді, яка
next
буде
conference
присвячена
in November
безпосередньо питанням,
that will
якими ви
devote it to
займаєтеся у
questions
вашому
that you
суді,
are
у вашій
dealing with
країні,
in your court,
питанням
your
штучного
country,
інтелекту.
artificial
До
intelligence.
наступної зустрічі.
Therefore, see
Пане
you
В'ячеславе.
next time. Vyacheslav, the
Пані
floor is
Наталя. Я з великою
Thank you,
приємністю
Natalia. It's
приєднуюсь
my
до
great
слів
pleasure to
подяки,
join
сказані пані
words of
Наталією,
gratitude
шановному
expressed by
керівнику
Natalia
Конгресу.
to esteemed Filippo.
Дійсно, ваші глибокі висновки,
Your
які ви
profound
зробили, які
conclusion
філософському
that you
заключенні,
made, your
теж
philosophic
підкреслені
phrases
окремо червоним
were
кольором,
also
показники, над якими хочеться ще
emphasized.
подумати.
These are the
Дякуємо вам
thoughts
за участь у
that
даному
require
заході.
further
А
consideration.
ми
Thank you for
переходимо до
participation.
подальшої нашої роботи. І
We
я з
now
величезною
continue
з
according
величезним
to the
задоволенням і
agenda.
великою
It's my
честю
great
хочу
pleasure and
представити
honor
наступну спікерку,
to
шановну
present
пані
next speaker,
Єву Вендлер,
esteemed Eva
віце-президентка
Wendler,
Асоціації
Vice
Європейських
President of the
адміністративних
Association of
судів,
European
судді Федерального
Administrative Judges,
адміністративного суду
Judge of the
Республіки
Federal
Австрія,
Administrative Court
яка
of
підготувала
Austria,
доповідь на тему
who will
верховенство
speak
права,
about rule of
законність права,
law in
виконання
the
рішень і системні виклики,
ECHA,
виклики
enforcement of
довіри
judgment
претензій.
and systemic
Хочу також
compliance
зазначити
challenges in
про те, що
comparative
шановна пані
perspective.
Вендлер є
I
однією з
must say that
найпопулярніших
Madam Eva
представниць
Wendler is
європейської
one of the
адміністративної юстиції
most
та
well-known
активною
representative
учасницею
of
в розробці
European
сучасних
administrative
стандартів
justice,
забезпечення
who took
верховенства
active
права
part in
Європі.
development of modern
Надзвичайно
standards,
цікава і
rule of law in
цінна
Europe.
ваша
Your
думка.
presentation,
Також
your
вже
opinion
професора
is
вашій
very
кандидатурі.
valuable for us.
Вам слово, будь ласка.
The floor is yours, please.
Yes, good afternoon. Many thanks for your kind words. Many thanks for inviting me. Many thanks to Natalia for sharing your dreams. You dream that in 1 year, the next event could be held in presence in Kiev. I share your dreams and I can promise I will be there. Meanwhile, I just can try to support you from distance, but my support comes from the bottom of my heart. Yes, now coming to my presentation, the subject I would like to address today may at first seem to be about other countries, not about Ukraine. However, I would like to explain why I think the opposite is the case. In my work within the Association of European Administrative Judges, questions of judicial independence and enforcement of court judgments are the center of what we do. And from that perspective, I want to raise a question that I think is directly linked to this conference. Ukraine has made a clear and irreversible choice, the choice to integrate into the European and EU legal order. And this is a process of building institutions, building judicial independence, building a legal culture in which court judgments are respected, enforced, including judgments of the European Court of Human Rights. Our conference today is about legal regulation and law enforcement under martial law. Exceptional circumstances call for exceptional measures, and that puts exceptional pressure on legal systems. But what happens if that pressure is not carefully managed? If judicial independence is not protected, but undermined either gradually or blatantly? What happens when judgments of the Strasbourg courts that are binding under Article 46 of the Convention are simply not implemented? This is not a theoretical question. It is happening within the Council of Europe system. And to make this concrete, I would like to turn to Turkey, because I think it's more powerful to look on cases that actually happens. The turning point in Turkey was the attempted coup d'etat of July 2016. Within days, the Turkish government declared a state of emergency. What followed was a mass purge through executive decree laws that was neither subject to judicial or parliamentary scrutiny. More than 130,000 public servants were dismissed, among them more than 5,000 judges and prosecutors. The Strasbourg court has since found in case after case that Turkish courts simply upheld these dismissals because they had been issued under an emergency decree, without examining individual circumstances, without effective judicial review. And this is the most relevant point for us. Emergency conditions do create legitimate space for special legal measures. The Convention acknowledges this under Article 15, but that space has clear limits. Measures must be strictly required by the situation, and individual safeguards cannot simply be set aside. Ukraine is actively working to maintain those safeguards under the most difficult conditions of a war. What the Turkish experience shows is what can happen when judicial oversight is not attempted, but systemically dismantled. I would like to put a human face into my presentation. I would like to give you a short input, what we learn as an association. I would like to talk briefly about our colleague Murat Aslan. He was president of YARSAF, the Turkish Association of Judges and Prosecutors, and he is a man who dedicated his professional life to defending judicial independence in Turkey. In 2017, he received the Václav Havel Human Rights Prize from the Parliamentary Assembly of the Council of Europe. He has been in prison since October 2016, sentenced to 10 years on terrorism charges, based largely on anonymous denunciation and the presence of a Bylog app on his smartphone. Bylog is an app that uses encrypted messages, and having this app on your phone is evidence enough for Turkish prosecutors and courts to issue a ruling. The Strasbourg court ruled several times that this approach violates the convention. Murat Aslan is not alone. I could name other colleagues whom I know personally and who are in the same situation. Now I would like to come back to the institutional picture and to the institutional situation in Turkey. Non-compliance in Turkey operates at two levels simultaneously. At the international level, Turkey has consistently refused to implement binding Strasbourg court judgments. These judgments ordered the release of detained individuals. The same pattern unfolded in the case Demirtas and in the case Yalchinkaya, where a retrial in 2024 simply ignored that the Strasbourg court had identified convention violations. At the domestic level, ordinary courts have refused to follow rulings of Turkey's own constitutional court. In the case of Can Atalay, the Court of Cassation openly defied a constitutional court decision. In the Karaman case, a court refused for the second time in late 2025 to implement a binding constitutional court ruling. When ordinary courts defy the constitutional court and the state defies the Strasbourg court, the entire architecture of a legal hierarchy breaks down. And what are the consequences for Turkey itself? When courts cannot be trusted to apply the law independently, when judgments can be ignored or defied, citizens lose confidence that the law will protect them. The separation of powers becomes a formality, and the trust, once lost, is very hard to rebuild. Ukraine knows this, and the choice Ukraine has made to align with European standards to protect judicial independence, even under the pressure of war, is precisely the opposite direction. It is a choice that builds trusts. That brings me to the question, what can the Council of Europe actually do if a country does not comply with the judgment rulings? The body responsible for supervising execution of Strasbourg court judgments is the Committee of Ministers. And when a state fails to comply, the committee can adopt interim resolutions. That means that the non-compliance is formally put on record and the pressure is in a way intensified. In the most serious cases, the committee can trigger infringement proceedings under Article 46, paragraph 4 of the convention, and referring the matter back to the court for formal finding of non-compliance. This happened precisely only in two cases, in the case Mammadov versus Azerbaijan and in the case Kavala versus Turkey. Mr. Kavala is a civil society figure. He is detained since 2017. He was sentenced to aggravated life imprisonment without the possibility of parole. However, the Strasbourg court ordered his release in 2019. At the Committee of Ministers' most recent meeting in March 2026, Turkey was formally noted to remain in serious breach of its convention obligations, and Mr. Kavala still remains in prison. In both cases, in case Mammadov and Kavala, the Grand Chamber made a formal finding of non-compliance. In both cases, the judgment remained unexecuted. There is no financial penalty system in place, so the most powerful legal tool available was used, and the highest level finding was made, and still nothing changed. So the system can document failure, name it, but it cannot force compliance. And that brings me to my concluding thoughts. What the Turkish case ultimately shows us is this. The strength of a legal system does not depend only on its architecture. It does not depend only on the texts of conventions, on supervision mechanisms, on the existence of courts at national or international level. All of that matters, of course, but it is not enough on its own. The strength of a legal system depends in the end on the people who uphold it, and in particular on us as judges. Of course, executive compliance is essential. When governments refuse to implement court judgments, when they treat binding obligation as optional, the system is undermined from above. we have seen what that looks like. But we as judges carry an independent duty. We have to uphold the rule of law because that is what our function requires, regardless of political pressure, regardless of circumstances, regardless of how difficult the conditions are in which we work. Ukraine administrative judges are doing precisely this under conditions that none of us in more peaceful parts of Europe can fully imagine. You are maintaining judicial independence, upholding legal standards, and enforcing rights during a war. And this is the foundation on which a credible legal order is being built. And for that, you have my deepest respect. And Ukraine is showing the way. Thank you so much for your attention.
Дякую, шановна пані
Thank
Венлер.
you, dear Mr. Wendler, for your presentation. It was very informative and interesting subject for discussion and for thought for the future. And also special thanks for your emphasis on universality of the principle of protection of judiciary, which does not depend on historical or social, political or economic conditions. Thank you for this, and special thanks also. I remember your point that the strength of the legal system depends on the people, first of all. Thank you for this as well. Thank you for this expression. I'm happy to give the floor to Ms. Natalia. Mr. Vyacheslav, you rightly mentioned the quote from the presentation of distinguished speaker, Ms. Yeva. I also liked the words and possibly our participants as well, that the greatest problem is that the architecture which was established in Europe, regardless that European Court for Human Rights forms the standards of fair trial, they're not always achieved in practice because of impossibility of the system which is built now to enforce the judgments. And maybe it's the task for all of us, lawyers, scholars, advocates, to think about this, to think about modernization of the architecture, to make sure that judgments are not only declarative, that they are actually enforced. So thank you very much to our speaker, Ms. Yeva, for very complicated issues that you raised. They are very important, and for staying with us, for being our friends, for the fact that jointly we're doing this new page, we create this new page for Ukrainian-Austrian relationships. Now I am pleased to give the floor to our next speaker, the President of Association of European Administrative Judges 2014 to 2023, the Doctor of Law, great friend of Ukraine, the expert. And thanks to Ms. Edith Seller, our All-Ukrainian Association of Administrative Judges was established. For all these years, it has active voice on all important matters related to the judiciary of Ukraine. And we always say that together our voice is stronger, and we always go together. Thank you for this, and I'm pleased to give the floor to the audience. Is yours, Ms. Edith.
Thank you so much, dear Natalia, for your opening remarks. Honorable ladies and gentlemen, dear colleagues and dear friends, it is an honor for me to participate today in this conference. Thanks for inviting me. And I'm truly moved to see so many friends together. And this is very important, an important sign also. Allow me, I cannot simply just move on with my brief presentation and contribution to the conference, but let me express my deep respect to you for your, how you say, your strength, your courage, and your dedication to keep this justice judiciary going on in Ukraine in these times, this important sign. And also my condolences, as I heard about the large attacks last night. My condolences to all who have been affected by it, and my deep respect to Ukrainian people. in thoughts and all support what we can give, we are with you. Let me move on with my, I only want to add something to the conference from a very practical point of view, some remarks and on some aspects on taxation proceedings, taxation sanction proceedings, so to say, which are the same standards everywhere in Europe. And I'm not sure if I can share here now because I have sometimes some technical issues. I prepared only a list of cases to which I want to refer very briefly. I am not sure. I tried to share them, but I'm not sure. Otherwise, could I ask them?
We will try to share
IT from your side because I don't. Perfect. Thank you very much. Yeah, perfect. Thank you very much. Perfect. The system of sanction is always multifaceted. It's presumably in all European countries. There are coercive penalties. There is some imposition for late filing surcharges, or there are also tax evasion or underpayment of taxes, and last but not least, tax fraud. So there are also criminal proceedings and administrative proceedings. The issue of human rights protection were perfectly flagged by Professor Baker this morning already. And so practically spoken, what are the legal consequences when there's a taxpayer violates the different duties? So when you have different fiscal sanctions and different results out of this, administrative measures, criminal measures. There's a serious tax fraud on the one hand side, and then we have administrative tax proceedings. So regularly, normally, in very often this case, there is concurring administrative tax proceedings as well as criminal proceedings, more or less in the same time. The same facts, but different proceedings. This brings me also what has been also mentioned by Professor Baker in some parts. I want to flag some areas, 3 areas I want to flag in a way. First, what is with this ne bis in idem principle? Because this pops up very often in tax proceedings. We see it in the jurisprudence and the case law of the European courts, of the Luxembourg Court as well as of the Strasbourg Court. Ne bis in idem and tax, that's an issue. The second point I want to briefly mark is spotlighted more on the EU legal order is the issue of principle of effectiveness, which also implies that administrative sanctions need to be proportionate. That's also an issue. And thirdly, only a very brief remark, what is the obligation with this binding effect when you have multiple judgments? The binding effect on another judgment when it's final or when it's non-final. There is also a recent case law of the court in Luxembourg. First, so only some words on this ne bis in idem issue, protection against double jeopardy, which was also briefly mentioned by Professor Baker this morning. It's a never-ending topic and very important, actually quite complex, with this demarcation line between administrative proceedings and criminal proceedings. First, only some words on the convention system. You find also some cases in here in the sheet of paper. Article 4, 7th additional protocol, that's ne bis in idem principle. The legal fundament is rule of law. That's a basis. What Eva has mentioned in her contribution before. It's always it's res judicata, rule of law, legal certainty. These are also basic principles involved in this ne bis in idem. So I only go that originally Article 6 of the convention was not there. It's one Swedish judgment, Lucky Devil versus Sweden, in which the Strasbourg Court partly included the taxation surpluses to say it's a criminal charge according to Article 6. So this was the first time when parts of tax law have been included into the system of Article 6 also as well. Basic principle questions to be asked in this context is whether an act constitutes a criminal offense. Is it a criminal offense? Whether the offense of which a person was already tried or punished again in criminal proceedings, or has the person been finally acquitted already? And a question is always, do we have 2 different proceedings? And the fourth question is always, is the first decision final? That's according to the convention system. The conditions, and only to just briefly to mention, is you have to be criminal. When is it a criminal sanction? We have the autonomous interpretation of the Strasbourg Court concerning the Engel criteria, what you all know. So this is decisive consequences. If this consequence represents a monetary recovery for the state, or if it is a sanction, it's a sanction against the person to discourage the person from doing so in the future. So that's a question you have to ask. For what reason is it? This is criminal proceedings. Is it a criminal proceeding? Is it bis two? Are there two proceedings, bis? We need to have two distinct criminal proceedings relating to the same illegal activity. So they must be closely connected. These two proceedings must be closely connected in substance and also concerning time. On the finality, there's also jurisprudence. Is it a final decision? Jurisprudence is irrevocable. For instance, that's important concerning the jurisprudence of the Strasbourg Court. Is it the same? And that's also quite complex. Sometimes idem. Is it the same violation? The Strasbourg Court has, how to say, maneuvered from the 90s up to now, and now it has been clarified that the idem is not the legal classification, but idem is the same facts. Solotukin versus Russia was the first case. Concerning tax law, I want to mention here A and B versus Norway, where the court also laid down specific, very important criteria and factors to say what is the same idem. Yeah, because this was a tax case, so very, very important, A and B versus Norway. So it took the view in that case that an application of punitive sanctions does not necessarily violate Article 4, 7th protocol, but only if these two proceedings, again, are closely connected in time and in substance. And this is very important criteria for the checklist concerning more or less in this judgment given as a checklist by the Strasbourg Court if we have double tax proceedings in line with nebis in idem or not. The close time connection is important, and also that on the matter between these two proceedings to avoid uncertainty. Each type of sanction pursues a different goal. So close time connection, different goals. That's important, so that the proceedings are complementary to each other, and that there is a collection of assessment and evidence is not done twice. Is there cooperation only for this reason? And the duality of these proceedings must also be foreseeable for the person, ex ante, foreseeable. And the overall punishment must be proportionate. I'll come back to this later on the EU legal order, but it's proportionate. I only mentioned also one recent judgment of the Strasbourg Court, Icelandic case, Gudmund Kristjansson versus Gudmund, a tax case, also where it confirmed this A and B case law. So that seems to be clarified now, but it took quite a long time for the Strasbourg Court to clarify, but now it seems that it found its way through. EU legal order, what Justice Nina Poltorok pointed out this morning, just to mention and also say, she mentioned Ackerberg-Franzen. This is a landmark decision, fundamental rights charter, very important. And in this case, this Swedish case, Ackerberg-Franzen versus Swedish tax authorities, was a Swedish case, tax case, and concerned this nebis in idem. So very, very important case. And therefore, I don't go into details, but only mention, and you find in the list, there is one more case also of the Luxembourg Court on these issues, nebis in idem and tax matters, Baldetti and Orsi case of 2017 was the decision, yes. And there is one more, a more recent, also a Grand Chamber judgment of the Luxembourg Court, also a tax case, VIT case, Italian case, Luca Menzi from 2018, the decision. So far, there is no really absolutely new judgments, but it's also the baseline of the case law and direction of the Luxembourg Court seems to be clear. There's no real problem anymore. Conclusion is, and both courts, Luxembourg and Strasbourg Court, are really refer to the same issues, so they are very go hand in hand. Similarities of their approaches. There is only that this sufficient time and substance connection as such is not a criterion in the Luxembourg Code, but instead it examines otherwise if it's justified and there's a legitimate limitation of the right. So in the end effect, both European courts go the same way, same line. And there's a general development that between the criminal and the administrative sanctions, it's less strict. It is seen to be less strict, and there's less and less nebis in idem problems compared to 20 years ago or 30 years ago. So this is the way the jurisprudence has developed, affects us all. The second point I want to briefly move is this proportionate sanction system. Concerning the Strasbourg Code also refers to proportionality of sanctions, and also in the EU legal order. Proportionality of administrative sanctions in the EU legal order is not something specifically concerning tax matters, but a general issue, because we have many EU law in all areas of law, and there is case law. I mentioned only one because it's an Austrian case, but there is case law, tax data I referred, and concerning these, the constant jurisprudence of the Luxembourg Court says any administrative sanction must be effective, a principle of effectiveness of EU law, dissuasive and proportionate. So that's a basic principle. It depends on a case-by-case basis. I only referred to and also listed in the cases because we Austrian judges had in area of law, not tax law, but we had really big issues in the last years on this issue of what is a proportionate system, because, for instance, some foreign workers, you have to make documentation when you employ foreign workers, and there were simple documentation problems. But the national law provided that for each worker a high minimum amount of sanction, and the accumulation of 100 workers, though this company would have needed to pay 3 million euro fines, sanctions, for some minor problems. So Austrian colleagues referred this case to the Luxembourg Court, asking about this proportionate system. The Luxembourg Court Maximovic case said no. And then we had a problem how to pack it into our national system, because the national criminal procedure, how to bring this in line with it. So there was a second reference, and now it's more or less clarified. But this affects all areas of law, and also for sure tax sanctions, administrative sanctions as well. The last point I want to mention, sorry, I hope I'm not too, don't talk too long, the issue of binding effects. When you have multiple proceedings, there is an issue. On the one scenario, you have a binding effect when there is one final judgment. This is, as sure you know, and you agree with me, this affects res judicata as a basic principle. How far does this binding effect go? There is one case, tax case I mentioned, Italian case already of 2008, but there was this issue with finality of tax proceedings, tax bill became final, and then there was the criminal proceedings, and this binding legal effect, one judgment on the other. And the other scenario, and there's a very recent case law of the Luxembourg Court, is what do you do when there is one judgment is not final? There's a Slovakian case and judgment of April 2026, when there is a first instance court decides, and the second instance court, in that case, there were real procedural flaws, definitely not minor flaws, because the second instance ignored the presumption of innocence. So anyhow, with these procedural flaws, second instance quashed and referred the case back to the first instance. And they referred the case now to Luxembourg, saying, well, how does it go? By national law, I'm bound by the second instance decision, not final. Where are the limits of this legal binding obligation that binding effect is? So I just wanted to mention this is a very recent case law, and this affects all areas of law, and as well also tax proceedings for sure. These were only some fragments I wanted to point out and contribute to the very big arena of taxation. And I want to send you again my best wishes and my true respect. And I hope to see you all in person soon, and Slava Ukraini, as you know. Thank you very much.
Героям слава, дороге
Glory to heroes. Dear Edis, I think that we should all applaud to you. Within such short presentation, you made such a fundamental review, real fundamental course. It is the course on the practice of ECHA and European Court of Justice. Within one presentation, you managed to do it. We received real great praise. You introduced both the view and the case law that we already knew, but different aspect from the point of view of a judge who is analyzing the case law of European Court in Strasbourg and Luxembourg Court. This is great use to us, and all that you are doing for us, for Ukraine in general. I hope real very much that quite soon, in the fall of this year, in November, we should have possibility to see each other in person. Thank you very much for all your visits that you organize for Ukrainian judges. Significance of those visits, contribution to our road to European integration is difficult to overestimate. I also want to sincerely join all the words that Natalia said to esteemed Edith Zeller. Thank you very much, Real, for such interesting presentation. We wish you all the best. Thank you very much for your support. Now allow me to mention next speaker, and I shall do it with great pleasure. Natalia Blazhivska, Judge of Cassation Administrative Court in Supreme Court, Professor, researcher of international tax law. She made a very good contribution in developing international doctrine, tax law, human rights law, and justice. And I want to mention that Natalia is moving forth, is the inspirer and organizer of numerous conferences and events. This is huge source of energy that inspires me personally very much and surprises me. So I think everybody will agree with that. So Natalia, the floor is yours. Thank you, Vyacheslav. I'm touched by such introduction, and you praised me to a great extent well in advance. So I shall speak and try to confirm your work. Dear colleagues, dear participants, in 1945 in Nuremberg, the court process starts that changed the significance of judicial system. The main prosecutor for USA said the words that are the strongest legal landmarks, I shall quote, crimes that we try to condemn and punish were so well thought, were so malicious and so ruining that civilization cannot allow itself to ignore it because it will not survive if it is repeated. That was told almost 80 years ago, but now it requires the new meeting, and you can address it to our enemy. Our enemy violated all the rules, all the norms, and civilization of the people cannot forgive it. It's not because Ukraine became the victim of the biggest war in Europe after World War II. Not because the international legal order is going through one of the biggest crises. The matter is that it raises the question, the answer to which should be found anew by new generation of lawyers. Will the law remain a law when the country is fighting for its survival? This is the basis of modern transformation of law. This is the starting point for all of us. It looks like my topic is narrow. Lex specialis of wartime in public finances here, but in fact, this topic is much broader. We speak how in the course of centuries, international law was changes legal order in public finances, how margins of financial sovereignty changed, and mechanisms of liability transformed, how international law impacted budgetary and financial legislation, and whether full-fledged invasion against Ukraine caused lex specialis of the wartime. That is the question which is actively discussed internationally. Some scholars and practitioners believe that modern sanctioned regime, international mechanisms, use money from frozen assets, shape the new regime of international financial law. Others caution from hasty decisions, saying that it should not change the uniformity of international legal order. And the line of development is in between. To answer the question that we formulated, you should get away from simplified approaches. Often you can hear that international law is limiting gradually the state sovereignty. Gerd Lauterbach, who is the graduate of Lviv School of Law, was born in Lviv area in Western Ukraine. He said that international law doesn't contradict, that creates conditions for its civilized application. Kelsen proved that states cannot exist without law. And we can look at development of public finance differently. From 2019 to 26, not only financial sovereignty was developed, but the legal ways how to implement it. War against Ukraine became a catalyst. It didn't create the new law, but was a catalyst. You must watch the entire history, the Versailles Treaty, up to UN statutes, use of international compensation mechanism, classical sovereignty and the modern mechanism of law. Gradually, we switch to understanding that law does not arise immediately. Its development, it's a lengthy process, and each historic crisis impacts it. And the previous speaker mentioned that, using example of their country. Modern financial legal mechanism must be seen as a result of 100 years evolution. First stage was Versailles system of 1919, after World War I. Last time there was a legal attempt to regulate financial instruments. Reparation became the new idea when aggression causes not only political but monetary responsibility, and that influenced decisions of the state and international community. Next turning point after World War II. It was mentioned by speakers today as well. Foundation of United Nations. That meant change of entire philosophy of international legal law. Now the task is not only to regulate the consequences of war, but as we see how to prevent repetition of that, whether it will be succeeded or not. At the same time, the new international financial architecture was developed. It was a qualitatively new stage. It was not only response to financial consequences, but definition of rules for financial. Third stage started after the end of Cold War. International law started getting more profound in financial system, countering money laundering and fighting terrorism, budget transparency, financial monitoring that impact national legislation. International law was not limited by establishment of general rules. It impacted more and more how states influence and implement their financial obligations. This transformation happened broadly after start of aggression against Ukraine. First, not only future reparation or liability in the future was discussed. International community focused on ensuring financial resilience of the state, that is defending itself and resisting enemy. International law started impacting financial legal order. International budgetary macro-financial assistance required, sanction policy, cost development of internal legislation, management of sanctions assets, and third is development of international compensation mechanism, register of damage and losses caused by aggression. This is the new level of international and national legislation. All mechanisms are based on existing principles of international law, sovereign equality, international responsibility, rights to self-defense, commitment to international law, and rule of law. Even in conditions of war, rule of law dominates. Each war was changing international law, but international law was changing international financial legal order. But none of the stages ruined this major principle. They just acquired new content responding to the challenge. Whether the current status of international law allows us about say that is formation of lex specialis, at first sight, the answer is yes. But unprecedented amounts of international assistance, new sanction regime, all that in fact create the impression that new special regime of international financial law appears. But the science requires more, and we shall refer to what is the existence of special norms that regulate relations. In the document offered by Commission of International Law of United Nations, offered it, you can read it. Now we talk about intensive specializations of mechanisms, how to use international law to unprecedented financial challenges. Not fundamental principle change, but the method how to implement them. That explains the high-level international financial support. All modern instruments have common goal. They don't change general law, but just develop it. And experience of Ukraine proves that. Next item that I want to focus attention in conclusion, because next speakers are waiting. Certain conclusions that in my view come from the everyday analysis. In the course of 2019 to 2026, national legal order in sphere of public finance were changes from reparations after World War I through development of international finance structure and current mechanism of support to Ukraine. This is a historical consecutive process. International law is impacting not only external relations, but impacts how budgetary policy is conducted. Second, modern development of international law doesn't allow us to conclude that an autonomous lex specialis of wartime has formed. But we witness other processes, general principles of international law, sovereign equality of state, international liability, right to self-defense, and rule of law acquire new sense in conditions of unprecedented changes. In other words, not fundamental principles change, but the way how they are used. Therefore, international law is not changing the scope of sovereignty, but changes mechanism of implementation. Ukrainian experience is important not only for national legal order. Our experience shows that the condition of martial law creates not only limitation, but creates mechanism for supporting a democratic state of Ukraine. But this support remains legitimate only when principle of rule of law is abided by. It's just rule of law that defines limits of state discretion, ensures balance between the needs of second, security and protection of human rights, doesn't allow special circumstances to turn into discretion.
This is why modern approach is important not only for Ukraine, it can identify the area of development, of international law for decades ahead. That's why today we have new understanding of interaction between international and national law in the area of public finance. Using Ukraine as an example. Once again, not because of ruination of sovereignty, but because of development of new legal mechanisms of effective implementation. And let me conclude where I started. Nuremberg trial. Robert Jackson mentions the responsibility of civilization to avoid repetition of greatest crimes. More than 80 years passed since then, and today international law faces a complicated issue to prove that even in times of war, the law remains the law. So a real trial for the rule of law is not the peacetime. In the peacetime, respect for law is natural condition of functioning of democracy. The real trial starts when the state is fighting for survival, for existence, when security challenges require quick and difficult decisions, and society expects maximal efficiency from the public government on actions of the enemy. In these conditions, the law is able to preserve its regulatory force and the state remains faithful to constitutional principles. In that case, we can talk about real rule of law, not as political slogan, not as a declaration, but as a real foundation of democracy and modern international legal order. And we demonstrate this on a daily basis. Thank you very much for your attention, colleagues. Thank you. Dear Ms. Natalia, it seems to me that you indicatively and convincingly illustrated that whatever is the aggressive manifestation of the right of force, it has to be actively countered by the strength of law. Thank you very much again for your presentation, and we can continue this discussion, and we can give the floor to Mr. Alexander Vodanikov, Judge of the Constitutional Court, candidate of legal sciences, who prepares the topic of his presentation, constitutional dimension of tax law. I'm very pleased to introduce Mr. Alexander, who is one of the most well-known Ukrainian experts on constitutionalism and rule of law. His many years of activity as the expert of Council of Europe and participation in European standards implementation and constitutional justice made him one of the key architects of modern developments of Ukrainian constitutionalism. Mr. Alexander, are you connected? Please, the floor is yours. Thank you, Mr. Vyacheslav. Thank you for introduction. Special thanks for the invitation to this very important event. Unfortunately, I was not fully present due to objective reasons. We have great chamber sessions, and the colleagues let me go for half an hour. With request to the Cassation Administrative Court, I'd like to continue this great point which Ms. Natalia starts. It's in the area of international law. Yes, it's not the principle that is changing during the war, it's the enforcement, application that changes. This point is important and feasible in constitutional law as well, especially when we talk about war, taxes, and constitution. For my presentation, I selected the topic, which doesn't sound related to war, but it was done on purpose, because we need to touch on the matters of constitutionalization of the tax law, what the Constitutional Court is doing at the same time to show how the war influences this important process. As you know, Constitutional Court and is only in the beginning of the way to constitutionalize tax law. And here we're grateful to be based on the development of Cassation Administrative Court as part of the Supreme Court. I expect that the matters related to tax law will get to us more and more. Why? Because there are two areas which interfere strongly into human rights, and with which individuals face in their life. It is criminal justice, and the second is taxes. Taxes are invisible hands of the states hovering over each citizen. I'd like to discuss this. I'd like to discuss the principles that developed in our constitutional doctrine and foreign constitutional doctrine, the areas of development of constitutional dimension of the tax law, and how important it is, how important taxes are for modern democracy. It was important, it is important, it will be important. The topic of my presentation is the expression by Kaspar Huk. It's one of the founders of modern tax law. It is medieval philosopher who formulated a simple point: every tax has to have fair and rational basis. This basis, maybe we don't study the works of Kaspar Klok at universities, we don't encounter references to this philosopher in the textbooks, except for textbooks on tax law. At the same time, this idea what was formulated for the first time by this German in the 17th century It is cross-cutting for all constitutional jurisprudence when we talk about taxes and democracy. And thanks to this philosopher, we have this fundamental differentiation between the fiscal feasibility and the legal legitimacy. Filling in treasury is not the ground for taxes. The state has to argue to justify not just the objective, but also the way of enforcement. This idea always emerges in the judgments of constitutional courts of democratic states. Moreover, if we look at the history of modern states, we can see that the issue of taxes is linked to the issue of democracy and the issue of constitutional democracy. The first notion in the history of law is Magna Carta of 1215. In item 12, it directly envisages there is clear fiscal right. The king cannot levy taxes except for the joint agreement of the kingdom. This is the first recording of this idea, of this most important principle of modern democracy. There is no taxation without representation. And the slogan, no taxation without representation, became the key motif for the modern states. Against the backdrop of American Revolution, this was directly recorded. It was developed in the Declaration on Independence and Constitution of the US. If we look, one of the most important arguments in favor of independence of Americans at that time was the slogan that the king did not consult with colony on introducing taxes. And because of this idea that there is no taxation without representation, the idea of modern democratic state is formed, which is constitutional democracy now. Scientifically, this became possible in the Declaration of Human Rights in 1789. Which remains important in constitutional law. In this Declaration of Rights, the important principle was built, which is decisive for constitutional review of any tax matter. The tax burden has to be allocated fairly. There is more than ability to pay principle, which arises. It is well known, but in these documents, there are origins which identify modern constitutional dimension of taxation, of tax in constitutional democracy. If we formulate the most foundational point for understanding of tax in modern democracy, this point can be the following. This is not an arbitrary act. This is not the act of sovereign, as in medieval ages. The tax always requires ongoing direct link between payer and the government. If we look at the idea itself of democracy, democracy is a republicanism, and a state, modern democratic state, is community, political community, which consists of equal in rights and dignity, equal citizens. The idea of citizenship includes contribution to the common good, which is implemented through the mechanisms of taxation. Once again, going back to point one, there are two areas that are the most sensitive for the human rights: criminal justice and tax law. These are areas of the most intensive intrusion of the state into freedom and property. And development of these two areas, criminal justice, since the times of Feuerbach, and tax law even earlier, since Casper Koch, they are developing as an instrument of objection against arbitrariness. If criminal justice has habeas corpus, tax law has a requirement of representation, where the modern principles arise that I mentioned before. This overlap illustrates that Constitutional Court of Ukraine made the judgment recently that in many aspects the same guarantees which arise from habeas corpus have to be applied in tax area as well. Now, with Mengel criteria from ECHR, practice third criteria and sanctions, but based on this Mengel criteria in tax law, there's old and lengthy joint European tradition of just taxation, which now arises in jurisprudence of the EU countries. As regards to the Constitutional Court, our case law is available in this area. It is limited compared to the jurisprudence of Federal Constitutional Court or French Constitutional Council, but it is available, and it develops important important aspects for constitutionalizing the tax law of Ukraine. This work will continue, this effort will continue. We will move with our colleagues with Cassation and Administrative Court in the same direction, and I already mentioned during the meeting with Administrative Court that our position in the judgment was caused by the jurisprudence of the Supreme Court, Cassation, Administrative Court, and positions that were expressed by Raisa Khanova. We wanted to mention her in the judgment, but then decided not to do this. But in the same judgment, we made a very important emphasis on the link between taxes and democracy, linkage which at the moment, unfortunately, is not so obvious in our tax law and legislation. Hopefully, Constitutional Court will have more chances to express its position on this matter. And this brings us back to 17th century. Kaspar Cloak used that rationabilis causa as the basis of modern tax law. We need to understand that this principle requires executive power and judiciary power. First, the protection of rights and freedoms of taxpayer. Taxpayer is a citizen. Even if we talk about legal entity is the establishment of citizens, of people. It is constitutional doctrine, equal treatment of all entities of taxation, ability to pay. Not even rates for everyone. The rate should be in line with ability to pay. And the third point is what was mentioned by Natalia, rule of law, an important aspect of proportionality, or being proportional. And the most important when we talk about taxation democracy, our basis is that Constitution and constitutional democracy prohibits application of taxpayer to utilitarian units. This reductionism is not in line with the idea of modern democratic states. We cannot follow the old Soviet concepts that the taxpayer is the servant of the budget. No, budget considerations are important. We even have the provision in the Constitution that the state has to aspire for a balanced budget, but it doesn't mean that this requirement has higher significance than rights and freedoms. This is very important to understand when we talk about tax law, which is as intrusive as the criminal law. regarding the rights and rights and freedoms of the citizens. I will not discuss the jurisprudence of my colleagues from foreign states. I believe that previous speakers already mentioned this. I'd like to underscore that Swiss Constitutional Court tried to pay attention to examine all principles which were formulated in the European constitutional tradition, and we tried as we moved to the EU to try to become part, to make sure our jurisprudence becomes part of the common European tradition, constitutional tradition, in particular in tax law and constitutional dimension of tax law. Going back to the topic of our today's discussion of our panel, war, taxes, constitutionalism in the extreme conditions. Once again, I'm very pleased that Natalia emphasized this, and I don't need to explain this in detail. The principles remain unchanged. What changes is the way of application, balancing, and so on, but the principles remain the same. Constitutional principles of Ukrainian constitutional democracy. The challenges of the wartime are huge. The pressure on constitutional restrictions. The state has to take all measures targeted at protection and defense, but even in these extreme conditions, this principle causa remains the same, it doesn't disappear. The balancing may change the weights that we allocate to constitutional values, taking into account current state of war and conditions, but the principle itself never disappears. The issue of feasibility cannot give weight to the issue of adhering to constitutional principles. Principles of equality, certainty, proportionality, respect to dignity are not repealed in the conditions of war. They are balanced, as I mentioned, as Natalia mentioned. It is also characteristic for modern constitutional law. Why? Because we are fighting for our state based on the principles of democracy and rule of law.
Last issue that I want to draw your attention to, we as Constitutional Court have already touched this issue to some extent. Why this principle of taxation is important for the democracy in general? Modern democracy is based on a simple but fundamental idea, on a simple but very fundamental principle, which is any democratic community, any political nation is impossible without trust. And this principle, trust, has constitutional meaning. If you look at our last ruling, it comes as most important motive. Possibly, this is especially important for tax legislation. This issue is one of the most important, criminal and taxation, or even under conditions of war. We must abide by this principle and ensure trust to Ukrainian democratic state. I thank you for the invitation. Thank you for attention. We thank you as well, Alexander. We thank you for your presentation, and you thank you, despite being so busy, and the need of being at two times at the same time, you managed to speak at our conference, and your topic is very significant. Natalia, the floor is yours. Vyacheslav, from me, myself, I want to say that your presentation, your honor, Justice Vodyanikov, is extremely important. I put down the statement from your presentation, and I think that all those who create norms of law must put down refusal from constitutional standards of taxation in condition of war, a risk to undermine democratic legitimacy, for the sake of protection of which we are fighting. This is a very profound phrase. Thank you for that. Dear colleagues, I must say that esteemed speaker has another important presentation, and maybe being organizer, we shall ask him, can our participants get your last presentation regarding time as an important category? This is the topic that is needed for analysis of all of us. Can we, as organizers, ask you to disseminate not only this presentation, but the other one that you wrote for 30th anniversary of Constitution? We would be very happy to get. Do you agree? Yes, super. Fantastic. So, dear colleagues, and now we come to the next presentation, and I have great honor to invite our esteemed colleague from Germany that represents German School of Financial Justice. Her professional activities connected with development legal approaches that ensure a balance between tax sovereignty of the state and fundamental rights of taxpayers by developing practice of your country. And since Roberta has already shared her views with judges who discuss tax cases, and esteemed Roberta, we have discussed it for many days. Each your presentation, each your statement is especially valuable for us. We thank you for that. We analyze it, and we would be very happy to welcome you personally in Ukraine and continue that. Now the floor is yours.
Thank you very much.
Дуже вам дякую.
Can be heard by the interpreters. Is this everything all right? I hope so, because
yes, interpreter can hear you. Yes, thank you.
Thank you very much. Yes, I'm very grateful to have the opportunity to talk again in this frame, because we just recently had the opportunity to talk to Ukrainian colleagues. Now, the topic is public finances in wartime. At the first instance, I had a certain, I asked myself how to talk about this, because something is obvious. The German approach in the last wars, we will certainly not take this as a model for anything, because every one of us knows about all the atrocities of Germany and the German politics, especially during the Second World War. If we are forced to reduce these atrocities to taxes, to money, we simply have to name the policy of Germany to expropriation, to confiscations on a simply racist basis. Germany used to practice exploitation of forced laborers, especially Eastern European, when you have to say it as it is. And of course, we do not want this again. Never again, never again. Under today's perspective, we enjoyed many decades of peace. And at this very moment, many Germans really hesitate to see the problem at all. They don't want to see the problem. quite recently, we have to say, the government created a special fund for the most urgent needs of our military forces. Many people are very reluctant to see the necessities because they see all the recent decades it worked without these funds, so costs money. And of course, we have to ask ourselves, where does this money come from? It has to be raised somehow. And up to now and currently, the state generally opts for debt. And this sort of policy, sort of tax policy, relies on the confidence that the necessary money, that the revenue will be generated in the near future just by economic performance. If we can rely on the fact that within a certain time economy will be all right, we will be able to collect sufficient taxes, so this is all right. However, Germany is a very export-oriented country and a trade-oriented country. And if there are some sort of international disturbances, of course, this will affect the economic performance as well. And I don't know what I have to name. There are tariffs, there are energy prices, there are problems with international trade routes, let me name the Strait of Hormuz and so on. So it's a question whether we really may rely on future, on economic performance within a near and almost near future. How does our law in general deal with crisis? Because in the last, as I said, in the last decades, we did not really see the military problem. And when we were preparing for this conference, we thought the worst crisis that came to our mind was the Corona crisis, which was considered by many Germans as a very severe crisis. I think they didn't see, they could not compare to what a real crisis is. I don't want to say it was nothing with Corona, but still there are other crises. And I really can state at the very beginning, at the outset, the method of dealing with this crisis suffered from the same problem as the method of dealing with the needs of the military forces. It really contained the same flaws. What did they do? Or to say it first, what was the problem to deal with the Corona crisis? We had several impacts on our tax policy and the tax practice, and these impacts were due to lockdown. First of all, we had quite a significant decline in the economic performance. Therefore, people had lower income. Sometimes they really suffered a complete loss of income and a loss of tax base. We had restrictions on the international trade, and we had some rather tiny, compared with it, tiny problems. Restaurants were closed, barber shops were closed, the retail shops were closed, and so on. So on the economic basis, our taxes rely on a certain decline. And on the other hand, we had some practical difficulties in collecting the taxes, and then dealing with the tax, with the necessities of taxes. The people normally have to fulfill some procedural requirements, and they had difficulties to meet these. The normal workflow with the tax firms was hindered. Some people couldn't show up for work. This did work, that did work. The workflow with the tax offices was hindered, was hampered, and so on. And what the German policy and the German tax administration in general did was looking for quite a lot of measures for relief. For example, I just collected some of those. Advance payments could be delayed. One could pay later. Some value-added taxes were suspended to provide relief. There were certain sorts of extra payments for employees. We decided that they could become tax exempt. We had in the non-profit law, there was some sort of health care or vaccination and all this organization. There was provided quite a lot of relief as well. Yes, insolvency. Normally it is if a company goes bankrupt, it has to file for insolvency, and this obligation was suspended for a certain time because it was said, oh, this is a temporary crisis, it will be repaired sometime. And last but not least, it was very important for a lot of people. Normally there are deadlines for tax declarations, and these deadlines were extended to really to quite an amount. It was quite generously. Sometimes there were some months or half a year or so. So people had much more time to deal with their tax obligations. So that was the answer of our tax law to the Corona crisis. And I obviously skipped the burning question. And the burning question was that the Corona crisis did not only impose some difficulties for taxpayers, but it made sure that there was a loss of the tax base. And this method I tried to describe to provide relief in procedural terms and to provide relief in sort of the material law. This method only works if the crisis is temporary. If I know the crisis will end in a certain time and there will not be the next crisis just waiting around the next corner, it's all right. But especially after the Corona crisis, we had to learn that this sort of optimism, which worked for a long time after the Second World War, wasn't really founded well. We experience the war you in Ukraine have to suffer. The international order we had really become comfortably accustomed to, is falling apart in a speed I could not imagine before. We relied on the world trade. We relied on exchange of international exchange of everything. This doesn't work in the way we were used to anymore, and this is why the method to provide relief in a crisis situation is really a burning question. Will that be possible? When and from what will the state pay all the debts the state is going into? So, what do you want to say if I'm just addressing problems with our method? What do we suggest? It is very easy to manage a crisis with money. If the crisis is not a problem in the long run, and if the money is not a problem in the long run either. And all procedural and substantive measures were based on this idea. It's not a problem in the very long run. But what do we do if the crisis and the money are long-term problems? If we lean back and think about it quite we try to stay cool, we should say probably it's advisable to do the exact opposite of what I described. Because if the very foundation of certain measures does not work, maybe just do the opposite. What should we do? We should not delay advance payments, but we should rather provide for payments to be collected promptly, not to become an not to head for injustice, but simply for a certain strictness. Let me put it that way. Maybe rather than to go down with the value-added tax, maybe we should rather try broadening of the value-added tax. Maybe some, not so many exemptions. We have a very complicated system between the normal VAT base, the reduced VAT base, no VAT. Does it have to be this way? Maybe I don't like the idea, but maybe we have to increase the tax rate. Germany, it still works with, we have 19% in the top. There are some places in Europe which have definitely more. Maybe we should opt for less tax exemptions, which could be a contribution to simplify law as well. In general, we have the problem the law is complicated and turns out to be even more complicated every year. Maybe it's time to turn around to provide for less exemptions and at the same time try to make it simply easier for everyone dealing with taxes, getting along with it. Maybe rather not to extend the deadline, but rather to shorten the deadline. Is it really necessary to wait 1.5 years after the end of a taxation period to fill a tax declaration? Maybe we could do it rather soon after the expiry of the taxation period. It's simply an idea. It is not. It's nothing people would be glad about. None of us would be glad if we had to do it. But if we have difficulty, I think it's better not to close the eyes and turn around and say, I don't want to see the difficulties, but it's better to face the difficulty and try to think about how to deal with it. The only problem is we have to sell the idea to the voters. And maybe it's the biggest challenge of all. It is pretty easy to change the law. This is technical. This is just technical. But how do we want to make it appealing to the people who are called to for the next election? And I suppose it will be a big task to raise some consciousness to make it clear that we have difficulties, that we have challenges in the modern time, and that these challenges are not solved by looking away, but by working hard and yes, being ready to maybe suffer a bit in order to gain something and to win in the long run. Yes, this was my message. As I said, I cannot really present the German way to deal with these with the necessities of the military forces. So I described it. We rely on the future, but maybe we do not have to rely too much on the future, but we have to take everything we can at this very moment to work with it. Now, thank you very much.
Це ми дякуємо вам, шановна пані Роберто,
Thank
тому
you,
що
Ms. Roberta, because
я маю сказати колегам, що
I
пані
have to
Роберта
say to the colleagues that Ms. Roberta now
відряджені у наших дорогих колег
is traveling
і тим не менше
to our dear
знайшла для
colleagues
нас
from Austria, but
час
anyway, she found time for
для того,
us
щоб
to
побачити,
participate, to see us, to make a presentation on the concepts. For us, Ms. Roberta, especially important is your vision and the conditions of the crisis that you mentioned that COVID brought, but you gave a number of important messages for us, like rethinking of tax exemptions. Sooner or later, it is the process that is underway at the moment in our country. Because of the current conditions we ended up in, because of the war. And so it is very important that you emphasize that this rethinking, this review has to happen with explanation, awareness raising at the same time for the citizens, for the public. It's very important that not only judges, not only scholars and lawyers understand this importance, but also our politicians. This communication with the public is an integral part of communication of the government in the legal country with the citizens, to get the support of the citizens and not to impose some position because we have crisis. Thank you very much indeed, and I have hope that in November this year we will have the chance to welcome you in Lviv. Dear colleagues, we come to an end. The first day of our conference is running to an end. On my behalf, I'd like to thank Raisa Fedorovna, Igor Vladimirovich for entrusting me to co-moderate this session. It's a great honor for me because today, me and Mr. Vyacheslav, we were trying to, dear colleagues, we're trying to work consistently in tandem to fulfill our objectives as moderators, and I hope that your evaluation will be high. Today we have done a real intellectual journey from financial effects of the World War I to the modern challenges facing Ukraine and democratic world. We so that despite different legal systems and historical experience, all our countries are united by joint values: the rule of law, independence of the judiciary, respect for human rights, and responsibility of the state to the society. It's especially symbolic that today we had our friends, partners, representatives of higher judicial institutions, universities, international organizations. The support, the solidarity, and readiness to share experience are very important value for us. I'm convinced that today's discussion will become the basis for new joint research, international projects, and further development of European legal dialogue. Also, I'm happy that the management and Igor Dashutin support this active European legal dialogue. Today, it makes us closer to the significant date for which we are waiting, the victory and joining the EU. Thank you very much, Mr. Vyacheslav. Thank you, Ms. Natalia. Once again, I'd like to thank every speaker who participated in this event. Thank you very much for your presentations. Thank you for your support. We feel that this is sincere, frank, and we feel your support. We feel your concern over the situation. We know that you're with us. Thank you very much for that. Before we move to as important next stage of our conference, the stage of digesting this information, reflecting on this information to make sure that tomorrow we start with new strength and new ideas to continue our work. I'd like to give the floor to dear Raisa Fedorovna and Igor Volodymyrovich. Once again, thank you, dear participants of today's event. Ms. Raisa Fedorovna. Maybe Igor Volodymyrovich can start. No, I pass the floor to you. I trust you. Thank you, dear colleagues. Thank you very much. We had very productive work today, despite crazy nights that we survived today. When we were drafting the agenda and topics, I imagined the aspects that will be covered and highlighted. However, I did not expect this depth of coverage and expansion of consciousness today. I was listening to these presentations and I have heard many, took home many points for myself. I was listening to all the speakers very attentively and I understood that this is the beginning of a new scholarly and practical research of public finance in the aspect of history, because we can have a look at the cross-section based on our points that we have heard today. We can do further analysis. It is the aspect subjects of the regulation and the aspects of transnational aspect, because public finance today cannot be treated separately only in one country, and even in the crisis in which we are at the moment. Because public finance is transnational in nature, taking into account technology, new technology, penetration of economies, and the most important, for the first time, public finance was mentioned by the lawyers who take care of financial law. And because history, development was discussed by state specialists or historians or those involved in the government, but in terms of the subject of regulation, specific regulation of financial lawyers, how they see it, how they analyze this, except Vyacheslav Vissarionovich, because he dealt with this problem earlier and he made a lot of studies, but otherwise it's open space. Everything has its beginning and the end, but today I believe that it's the history which will have the continuation. So thank you very much indeed. I hope that the nights will be quiet, peaceful, and we will have a good sleep, and tomorrow our two great speakers will continue And our moderators will continue our second day of the conference, and also we'll have a productive day tomorrow. Thank you very much, and see you tomorrow. Dear colleagues, dear Raisa Fedorovna, Vyacheslav Vissarionovich, Natalia Evgeniyevna, I would like to thank our guests, and Ms. Edith, and Ms. Roberta, and Ms. Eva, also Mr. Alexander from Constitutional Court made an important presentation. Everyone prepared, and not just prepared, but the topic was selected very successfully for this international conference. I was involved personally, and I felt what is the teamwork. I mentioned this to Ms. Natalia and Teresa, that if you have a team like that, you are not afraid of anything, and we have some prospects, and we have some ideas, and we already discussed a conference in Lviv. And this is very important for us, because I don't want anyone to live through the moments like tonight, and anyone found strength and implemented this day one of our international conference, for which we prepared for a long time, where this planning, we had some obstacles, but together we overcame those obstacles, and we resolved all issues. And today, despite events, overnight, I follow the news all the time. There are many casualties, and this is very sad to read and to understand what relatives feel, but we need to be strong, and because we have to talk about our prospects. It's very important for us to be heard, and the lawyers and judges of cassation administrative court understand that for establishment of state, and it is very important to preserve the institution of the Supreme Court, and the topic of public finance is extremely important. It is the existential topic, because it determines the investments and recovery and reconstruction. We'll have recovery after our victory, and it will take many years. It is the job for our children and grandchildren to ensure the recovery of our great country. Thank you very much for today's sessions. I'd like to thank all those who were involved in planning, those who made presentations, those who made speeches today. We are the best, and today we mentioned with Raisa Fedorovna, we have a record number of participants joining us today. We felt the interest, we received the feedback, we had ongoing correspondence in the messengers. It's nice that people understand the deep and important work that was done by all the team. Thank you very much, and I wish you a peaceful evening to all of us. See you tomorrow. Thank you, and see you tomorrow. Bye. Goodbye. See you tomorrow. Bye. Have a great evening. Goodbye.